Tom. Next to Kevin is alternate Martha Pennell. To my immediate left, Vice Chair Esther Olson Murphy. To my far right, regular member Laura Davies. And to my immediate right, Teresa Page, who is the clerk. And I guess we have 5 regular members. We'll all participate in the questioning this evening. But the 5 regular members, unless you'd like to be voting on one of them, I think
No, we have 5 regular.
Okay. The 5 regular members will be the voting members this evening. So we have 2 items of new business. So let's get right to it, shall we? First public hearing is the application of 81 Front Street LLC for a variance from Article 4, Section 4.2, Schedule I, and Section 4.3. That doesn't count as an error.
Nope, does not.
She counts my errors. And Section 4.3. Thank you. Okay, if I do it twice, it's an error. Schedule 2, to permit multifamily use in the R2 zoning district where only single-family and duplex structures are permitted. The subject property is located at 81 Front Street in the R2 single-family residential zoning district. It is tax map parcel 72-195, and this is ZBA case 23-14. This application was previously scheduled to be heard at October 1st meeting. So,
We have a microphone issue, it appears.
to whoever's out back, we're missing a microphone. They're out there.
I've seen him.
Thank you, sir.
Thank you for noticing that, because I wouldn't have missed it.
Good evening.
Good evening. Are we ready? All right.
Floor is yours.
Mr. Chair, members of the board, my name is Sharon Summers. I'm an attorney with Donahue, Tucker, and Chandela, and I'm here tonight representing the interests of 81 Front Street LLC. With me is the applicant, the owners, Steve and Karen Wilson of 81 Front Street LLC, and also Shane Forsley, who is the general manager of Hampshire Development Corporation. We are here tonight to seek a variance to allow the existing residential structure on the property to be converted to 6 residential units. And what we would propose to do tonight in the way of a presentation is to have Shane Forsley, first of all, provide you an overview of the proposal along with some related language about the properties in the neighborhood. And I will then, for the record, review the variance criteria that I have previously presented to you in the written narrative. Before doing so, I would like to provide you briefly with some context for this application, particularly since we submitted it back in October and we continued it in order to kind of regroup. So the first thing that we had our site walk this afternoon, and thank you for those of you who were able to participate. Hopefully that was helpful to you. The property itself is 1.8 acres. The original building was constructed in 1823, and as was seen today, there are a number of contiguous parts to the original building. The property is in the R2 zone, and the front portion of the property is in the historic district, but not the entirety of the lot. As you saw today, there is approximately 16,000 square feet of living space, finished living space, and we would like to create something that we believe which is going to make more sense in the current era. We believe, qualify for a special exception for 4 units or 2 as a duplex, but we believe that even 4 units would be too large to allow. And so what we'd like to do today is to seek a variance to allow conversion which is larger than we would otherwise obtain as a special exception, but we believe is going to be more appropriate and more functional. We will also address some of the abutter opposition letters and the comments in those in more detail, but at this time, I just want to touch upon a few key points that I ask the board to bear in mind as we go through our presentation and also listen to some of the abutter comments. And these are as follows. First of all, as we noted today, there is going to be no exterior changes to the portion of the building which is going to be facing Front Street. Second of all, the Exeter zoning ordinance defines multifamily as 3 or more units. And since we could have 4 as a special exception or under a special exception criteria or scenario rather, then the notion which is repeated in many of the letters that we simply can't pursue a multifamily, we believe is inaccurate because this ordinance does contemplate expressly that a special exception would be allowed for 4 units, which by your own definition is defined as a multifamily. The third point that I'd like to make, which is that in a number of the pieces of correspondence, the legal standard for some of the variance criteria is misstated. As this board well knows, some of the key pieces of New Hampshire case law are the Malachi case, the Chester case, and the Harborside case. And these cases taken together are critical in determining what is called the public interest standard. And unlike many of the comments that are raised in the letters, the public interest standard does not have anything to do with whether or not the public gains by the proposal going through or not through. It has to do, under New Hampshire case law, with whether or not the essential character of the locality or the neighborhood is going to be changed if the proposal goes forward. The last piece I'd like to mention, again, and this just is by way of context in terms of some of the comments in the abutter letters, is that the jurisdiction of this board relative to traffic is limited, and I know this is true because I know the board knows this, but I just want to state this for the record. The jurisdiction of this board relative to traffic issues is simply to determine whether or not there is adequate parking on site. Any other traffic issues in terms of operational issues and so forth will be dealt with by the planning board as part of the site review process. So with those sort of preface comments in mind, I will now turn this over to Shane Forsley, who is going to do a PowerPoint presentation of the actual proposal and also give us some information on the the neighboring properties, which I think is going to be useful for you.
Thank you.
I will note, just mechanically, Shane is going to be talking about a site plan which is going to show the parking spaces. The plan that he's handing out to you right now does not show those parking spaces. We will submit a copy of that later on for the record, but you'll be able to see that on the screen.
Sharon?
Thank you.
This is different than what we were, what's in our packet?
Thank you.
They're just going to do it. Same version.
That's the new.
I'll use this so we're all referring to the same.
Thank you.
Yeah, let me just see here. Oh, you've got the 8 units.
I do. I also have the 6 unit right here underneath it.
Okay. So we can use, for clarity, we can use this plan.
I'll use the same as, I'll use the one that he just
Yeah.
handed out.
Yeah, okay, perfect,
Sorry.
perfect.
Good evening, Chairman, members of the board. I'm going to hop over to the computer now.
Got that, thank you.
So the information you have in front of you tonight includes an annotated site plan here, which encapsulates the entire site at 81 Front Street. And what I'm going to jump to is a PowerPoint slideshow, which will show you a few different perspectives as you make your way around the property. I know a lot of you were able to attend the site walk here tonight, so it'll be a lot of the same information you saw today, but wanted to make sure that you had it here for record as well. A few things to note. We're going to start from the front of the property, essentially the driveway on Front Street, make our way towards the rear of the property along the right-hand boundary line, and then it will come back to the front of the property, front left, and work our way to the rear as well. A few things to note. The original historic structure is shown dashed in red. That is the front portion of, which is the front portion of the building here, surrounded with the red dashed line. There's a small connector and then an attached carriage house, which is the original structure, we'll say. The remainder of the area in blue to the left and to the back of the property, as well as the detached garage, that is a modern addition, which you will see in the photos.
Maybe should move.
And so I'll start from the front of the property here. So this perspective here is if you're standing at the front of the driveway, facing what is shown as the what we call the doctor's office. Historically, this is where Dr. Otis had operated their business over time. Panning left slightly, you'll see a viewpoint straight down the driveway towards the rear, where you'll notice a 3-car garage and a little snippet of the carriage house just to the right of the vegetation. And up front, you'll see a small walkway that extends along the front of the property up to the entry door to the original house and around to the left-hand side. Looking across the front of the property, you'll notice the vegetation, the gate, and the front of the original house. And we will tour you around the left-hand side later in the presentation. Moving a little further along, you'll notice the original carriage house, which has been converted to living quarters, which I know a lot of you got to see tonight. The 3-car garage, which was a modern addition, as well as the side entry to a potential unit. A rear snippet of the doctor's office that's detached from the property. And again, the carriage house and a side entrance to the original structure. This perspective is facing back towards Front Street, so you'll see the backside of the original house. And also you'll notice the lower roof that extends across, which was in addition to the original structure. This viewpoint here is important to notice. As we mentioned in our site walk earlier today, what's beyond those trees was the area of the connector, which we explained would be removed, allowing the original structure and the modern structure of the rear to stand on their own with adequate separation. This shows the side yard to the right of the garage. The side property line is a few feet beyond the fence on this perspective. And as we carry further back, this is the back side of the garage here. Beyond the garage, as you'll notice in the site plan, there's a large in-ground pool and a large in-ground hot tub, which has been neglected and abandoned, which we intend to backfill to make safe and return it back to a more natural habitat with vegetation, patios, that sort of thing. looking beyond the pool, what you see here is a former spa house and men's and women's locker rooms. This is the future potential of this includes conversion to living quarters, bedrooms, bathrooms, and so on. Now we jump back ahead to the left-hand side of the original house. So the walkway you see here would take you across from the driveway off of Front Street towards Seminary Way, and this is looking back towards that driveway. There's many walkways across the front and sides of the property, but what you see here is the original house with its original chimneys and all the original features, with just a modern addition or a screened porch attached, which is the roof line and structure you see closest to you. Another snippet of some of the landscaping and the structure as it extends beyond the original house. Here you see the large side yard. In the background you can see the fence that runs parallel with Seminary Way. Here, looking back at the original house, you'll notice a connector as well as one of the modern additions. Again, looking back at that same screen porch, just beyond that porch is the original house, living room, dining room, which you got to see earlier today. And again, another perspective. To the right-hand side, that's all the original building. The low roof you see is a modern connector and an additional room to the left-hand side of the frame. Here is about the midpoint of the original structure in the property. So I'm approximately 75 feet back from Front Street, standing in the side yard with my back to Seminary Way, looking at what is the indoor pool room, which you got to see. And to the left beyond the fence is the detached garage that you'll notice close to the end of Seminary Way, where there's a driveway and additional parking. In that garage is a standby generator and some equipment, which provides not only power but heating and cooling to various areas of the property. Again, on the left-hand side here is a shot of the indoor pool, and beyond in the background is the original house. And from this perspective, we're probably 15 or 20 feet from the fence behind me, which runs parallel to Seminary Way. In this photo here, that is actually the connector, which if you look on the site plan, I've got clouded in red. That's the connector which we explained would be removed to create a separation between the original structure and the addition at the rear. Right now, that's a approximately 6 foot wide climate controlled enclosure that essentially connects you from the front of the house to the rear. Looking back, you'll see the large areas of patios and green space continued all the way to the rear. In the very background, you'll see the fence, which ties into the rear of the structure. Here, through the double French doors, essentially that would be an entry point for the rear unit, which will be spoken about later in the presentation. This was an area where we exited out onto when we took our tour from the inside of the building out to the exterior. Again, looking back, that's the detached garage right near Seminary Way. Beyond there, there's a driveway and some parking area. Panning right just a little bit, this is the backside of the indoor pool. And beyond there is the connector to the original house. And you can kind of see it beyond the foliage right in here. That is the back of the original home. Standing about 3/4 of the way to the rear of the lot and facing back towards Front Street. This is the view. Seminary Way is on the right. The detached garage is there, and you can catch a corner of the enclosed pool on the left-hand side. And stepping a little bit further back, this perspective is from the patio. Again, what you see here is the enclosed pool, which my cursor is on, and the connector, which we keep referring to. That is the walkway between the original structure and the modern addition of the rear. Another perspective of the same, side entry point for what would be the rear unit of the property, the connector again in the original structure. Another snippet of the vegetation, the beautiful landscaping, and the patios that we spent a few months cleaning up over this past season. Again, that's the side entry to the rear unit to the right-hand side. This perspective here shows you at the curb cut on Seminary Way, looking at the property essentially head-on in the driveway. You'll see there's plenty of room for parking. For a few vehicles here, a large dump trailer and a truck. To the right-hand side, which we will pan to in a moment here, is a driveway and enclosed garage, standby generator. And just beyond, you see the gate to the playing fields in the school, just beyond on Seminary Way. Here, just beyond the fence, I don't think we poked around this far, but beyond the fence, there's a fair amount of landscaping before you get to the small bit of creek. There's my dog, Daisy. And here's essentially the rear of the building. You'll notice some mechanical units which service the back portion of the property. In this structure here, what you see is the three-season or screen porch that was right next to the in-ground pool and the men's and women's locker rooms or restrooms right here. So plans to redevelop this space into fully functioning interior space. And then just a snippet of the rear corner. And one more shot of the rear of that building. One more shot from the side of the property, right along the line in the fence along Seminary Way. One snapshot of the connector again. We thought it was important to capture it from this side. This is standing in the driveway with the 3-car garage to my right. Essentially, this is the interior space right off the garage, and through this doorway here is the connector, and you'll see the interior. So it's about 30 feet long, approximately 6 feet wide on the interior, and that's what we've proposed to remove to detach the original structure from the modern addition. And that's facing back towards Front Street, and that's facing the opposite direction. And that's on the inside looking out. It's hard to see, but essentially facing the driveway and looking back towards town. And that's looking out into the garden, spun around 180 degrees. Just a few more shots of the patios and landscaping. And so I know one question that the board had, which I will address here, is a parking exhibit here. And so what you see off of Front Street, currently there's enough room for 2 cars along the side entrance to the original house and the carriage house, as I call it. 3 spaces on the right-hand side, nose in towards the towards the fence. 3-car parking, undercover in the garage. And then off Seminary Way, you've got a single-car garage with parking and spot for 3 spaces in the paved area. And I'd be happy to answer any questions you may have.
Thank you. Any questions at this time, or should we turn it over to Ms. Summers? Please.
I have one question about, I guess, the parking and the flow. So there are 2 driveways, one off of Seminary and one off of Front Street, correct?
Correct.
And it does not look like those connect. So those would be, people would be driving in off of Seminary, parking in spots 9, it looks like, through 12, and then backing out, going back out Seminary to Front Street, and then the other tenants would all be coming in off of Front Street.
Correct. So the way the traffic flow is now is you've got your driveway off Seminary Way, which would support the 4 spaces, and then you've got the additional 8 that would come in off of Front Street.
Is Seminary Way a public right-of-way, or is it private? I forget if we brought that up.
Why don't we do you just want to answer that in a minute? Are there any other questions for the gentleman about the structure of the building? It appears that you're not changing the impervious surface pavement at all. There's no additions to the pavement that are planned. Is that correct?
Correct.
Okay, thank you. Any further questions for the gentleman?
It wouldn't require some additional paving in the spaces 1 through 5?
So what we did here was for illustrative purposes. Of course, if we needed any more paving or any sort of on-site work, we'd expect to have a full analysis done with an engineer, and that would go through the planning board, of course.
It appears it would be minimal anyway, but just, okay.
The members of the public will have an opportunity to ask questions later. Sorry, we're not in public session yet. It's all right. I just saw a hand go up, so I wanted to. Ms. Summers, do you want to?
Actually, I think what I'd ask Shane to do before he sits down is to briefly go over the Google map that we have and the data that we have about the neighboring properties, and then if you could just do that, and then I'll do my variance for the period.
And do you want to address the question about he looked at you when it was asked whether Seminary Way is a public road or not?
I can do.
Or, yeah, I got it.
Just the microphone.
Is it okay if I move this thing up a little bit?
Yeah, absolutely. I don't know why it's so far back. It's weird that it's back that far. Just hold it. It's karaoke night.
Right. In answer to your question about Seminary Way, this road is a road that is owned by the Exeter School District. My understanding, and based upon the research that we have done to date, it is a road that was originally owned by the town. The town conveyed that to the school in 1948 and has since that time been used for school purposes. The property, the subject property, and I believe the property across the street too, has historically used Seminary Way as a driveway.
Okay.
And just a quick question about Seminary Way. It is not open to through traffic. Is that correct? It stops where the gate is so that public
That
traffic.
is my understanding.
Okay.
That is my understanding, because it services the school.
Okay.
Yes.
I'm a graduate of the seminary. I walked down that lane many a time. My understanding is that belongs to the school board, the Exeter School Board. Have you approached them to do that? Do they know anything about this? We are the school board. In other words, the town is taking on the responsibility, I guess, of plowing it up to the gate. Is that a town road, or does it still belong to the seminary? I think to the school board. I just would like the school board to weigh in one way or the other about that section.
So let me try to answer that in a couple of pieces, okay? First of all, the property is shown on in terms of the deed and also on the tax maps as being owned by the school district. My
Yes.
understanding is that the town, as is customary with any kind of school property, it is going to plow what is functionally that driveway, okay? So whether or not, and in terms of what that plowing, nothing is going to change as a result of the proposal. I think that's the key point in terms of the school operation vis-a-vis plowing or anything else like that. Now, certainly, the school isn't a butter. They got a notice about this. And certainly, as part of the planning board process, when it comes time to site review, they would be consulted, and certainly they can weigh in on the kinds of issues that you're talking about. However, what I would say is that historically, the area that we propose to use for access and egress onto Seminary Way has been used for that exact same purpose, and in largely the same types of numbers that would be there. As Shane has just depicted for you, the little driveway area is big enough to contain a couple of trucks. There's a garage there. So whatever's going to be happening with this proposal vis-a-vis Seminary Way is going to be functionally the same as what's been happening there for years anyway. And the school will certainly, I mean, they have had an opportunity to participate tonight. They would also have an opportunity to participate as part of the planning board process.
Thank you.
I actually have a follow-up question to that, which I understand.
Sure.
I understand your comments. You said it's been historically used. It sounds like you've done some research that there is no easement or other, right-of-way on the record for this access.
My position would be that there is an implied easement at a minimum for us to be able to use this. And I can't speak to the driveway across the way. I haven't researched that. However, based upon the historical use of the property, I believe that there is an implied easement to be able to use that.
Okay. That answers my question.
Okay.
You had something else you were going to ask him to?
Yes. What we've done is that we have prepared some information about the properties in the neighborhood and the uses that they have. I'd like to have Shane walk through those right now so that will
Sure.
set up my discussion about the public interest and the character of the neighborhood. So here you go.
So what I passed out earlier, and what you see on the screen here, is a snippet of the zoning map and parcels, which we took 500 feet in either direction, up and down, or actually I should say, to the front and to the rear on Front Street from our property, and also went as far as 700 feet to the downtown side and away from downtown, up and down Front Street. And we captured a sample area of 30 properties in town. And what you see on the table here has been organized into 3 categories: single family, multifamily, and commercial/institutional use properties. In that sample area of 30 properties, there are 13 single-family homes, including 81 Front Street, subject property, 7 multifamily properties, and 10 commercial/institutional properties. So a few statistics for you here. 81 Front Street is a 1.8 acre lot. There is 14,822 square feet of living area on our property. In comparison, the average acreage within our sample area was just under 3/4 of an acre for single-family homes. For multifamily homes, just under half an acre, 0.463. And for commercial and institutional, just slightly over 3/4 of an acre. And so what you'll see of those 30 subject properties, we've got addresses, their use, as well as lot size and living area and square footage for comparison. And it really shows that there is a broad mix of things up and down Front Street, as well as the abutting streets. Not only Phillips Exeter Academy, but there are also rental properties, multifamilies, a number of churches, the Exeter Inn, and funeral homes. So we just want to make it clear that in this relatively small sample area, although close proximity to the property, there's a variety of those uses.
Thank you for preparing that. It's good to have.
Good information.
Can I ask one question about your averages? The average single family, are you excluding 81 Front Street from that average? Or do you include it?
This year was comparative.
Okay, thank you.
So it was excluded.
And pull the average way up.
Yeah.
So,
Lot size as well.
All right. So what I would like to do now is just to walk the board through the variance criteria for the record. Obviously, a number of these points have been laid out in the narrative, but I think it'd be useful just to go through this again. First of all, the variance is not going to be contrary to the public interest. The board is very familiar with this test. What I would say with regard to this test as applied here is that the purpose of the ordinance is silent. I think that what we can assume is that the basic objective of precluding multifamily residential use in the R2 zone is to prevent overcrowding. The manner of the test, which the board knows, is that to determine whether or not that basic objective is going to be unduly violated is to look at whether granting the variance is going to alter the essential character of the locality. We contend that there is no specific character to this locality, and I think has been evidenced by the evidence that we just presented here, that while there are some single-family residences in the area surrounding our property, there are also a number of other types of uses. As Shane has indicated, there is a church 2 doors down. There is a funeral home not too far away. There is a school immediately behind us. And 2 doors down from us, there is property owned by Phillips Exeter, which is used for student housing. So I think that information, coupled with the other information that we presented on other multi-residential properties in the area, clearly shows that this is not a monolithic type of use, contrary to what may be in the opinions of the abutters. In addition to the fact that there's no essential character here that's going to be disturbed, I would also indicate that what we are proposing to do is going to entail transforming the interiors. As we've said before, the exterior of the structure, particularly that side which faces Front Street, is not going to be altered. The proposed use of the multifamily dwellings does not pose a threat to public health, safety, or welfare. The use is going to continue to be residential. Public safety is going to be increased. One of the things that Shane didn't mention, and I'll let him speak to this if I'm getting this incorrect, but one of the benefits potentially of removing that corridor, which would separate out the original house from the other portion, would also be to provide, if needed, further access in the event of emergency needs and so forth, which right now tends to be hindered by that corridor. In addition to that, and there will be a number of renovations done on the exterior, which is going to bring this into code, and with the NFPA, such as firewalls. I know that even today during the site walk, Doug Eastman mentioned that the stairways and the entryway are not up to code because they kind of they're in that elaborate, very beautiful circle, but apparently inherently dangerous. So all those things will be addressed as well. So, in short, the character of the neighborhood, which is, by the way, I should note that there is no definition in your ordinance on the word neighborhood or locality, and those are the two words that are used in the New Hampshire case law. If you look to Webster's Dictionary, which of all things is what the New Hampshire Supreme Court has directed us to look at, the definition of neighborhood is people living near one another in a section lived in by neighbors and usually having distinguishing characteristics. So one of the things that I would say is that based upon the evidence that we've been able to compile, this area does not have distinguishing characteristics and is in fact kind of a mixture of things. So that's public interest. The next criteria is the spirit of the ordinance. This is observed, as the board knows, under the Chester case. This criteria simply follows along the path of the public interest. So that criteria, we believe, has been answered. The values of the surrounding properties will not be diminished. Our position is that the lack of the change to the exterior of the building indicates that it's not going to constitute a diminution in value because the appearance of the building will not be damaged. And in fact, as has already been evidenced today, with the improvements to landscaping and whatnot, in fact, the value might be enhanced. The multifamily use, which we propose, is allowed via special exception, and in fact, there are some other multifamily in the area. And that would be allowed by special exception up till 4. What we're proposing really is only an incremental increase above and beyond that to 6. So our position is that we do not believe that this is going to diminish the property values. I know there was an appraisal that was done, which I intend to address later on following the abutter comments. That only came in on Friday. I have had some of an opportunity to review it, but I will be addressing that later. The third criteria is whether or not substantial justice is done. And again, as this board knows, the legal standard for this is not what one would normally think. It's not whether or not substantial justice is going to be done on a sort of a metaphysical level, but it in fact is a balancing test. And what this board is charged with doing is determine what is going to happen to the applicant if the variance is denied, and then to look at what the public gains if the variance is denied, and whether or not that benefit outweighs the loss. If it doesn't, then the variance is supposed to be granted. So applying that test to the facts here, we believe that there is no gain to the public which would occur if the variance were to be denied. As has been discussed already, we are in a position where we could apply to get a special exception for 4 units. We also believe that there are other avenues that we could take to achieve a similar result. So even if this were to be denied, and we don't believe that it would, it's not something that would foreclose our ability to pursue a multifamily on this property. By contrast, if the variance were to be denied, we believe that the applicant would suffer as a result of this. As the board saw today and has been discussed tonight, this is a property which is huge. It is ginormous. It is 16,000 square feet. And I do know, my understanding is that prior to my client's purchase of this property, it lingered on the market for over 3 years. We believe that the prospect of trying to find a single family to buy this, while it's possible, is certainly not readily available. And certainly that the appropriate measure of trying to find the size of units that we think would be compatible with the Exeter market is more along the lines of 6 rather than 4. So we think that there would be a loss to this applicant if this particular proposal were to be denied. The next criteria, the last one, is unnecessary hardship. Now, the first element of this, of course, is whether there are special conditions of the property. And this, among the many applications that I have done over the years, this one certainly gets, I think, the prize for special conditions. It has 1.8 acres, which makes it larger than the abutting lots, which have residential properties on them, and it's larger even than the Exeter Inn, which is a functional inn, which also has a large dining facility. The structure on the lot is, you saw it today, it's one building with contiguous portions, 275 feet in length, 100 feet in width, 16,000 square feet, 4 kitchens, 3 bathrooms, 6 bedrooms, and 23 rooms. It is astonishing.
Same as my house.
Exactly. 15 bathrooms, pardon me, I stand corrected. So I think inherently this property has a number of special conditions associated with it. And I would direct the board to the ruling of Harborside, which specifically allows for the board to take into account the size of a particular project in determining whether or not there's special conditions. The next criteria under the hardship analysis is whether there's any fair and substantial relationship between the general public purpose of the ordinance and the application to the property. Here, we don't think that there is a fair and substantial relationship. As has been discussed before, we believe that most likely the purpose of not allowing this number of units by right or by special exception would be in order to prevent overcrowding. I would indicate that with 6 units, we meet the density requirements. Further, the massive size of the structure and the lot, together with the absence of any change to the streetscape, all of those things are going to prevent the sense of any kind of overcrowding. All of the changes will be done on the interior of the building. And, as I've said before, relief would be readily available in the form of a special exception to define something which by ordinance is already considered a multifamily structure. So again, we don't see that there's a fair and substantial relationship between what the ordinance is trying to control and what we're doing here. Finally, the proposed use is a reasonable one. This is a 1.8 acre building. It has a massive number of rooms and of square footage. It is ready-made, we believe, for a use in this time and this era of something which would be other than single family. So with that, I would like to entertain any questions which the board may have. And obviously, I'm going to reserve the right to speak after the various abutters have presented themselves.
Thank you, Ms. Summers. I appreciate the presentation that both of you have made. I have a quick question, which I'm sure is going to come up at some point later in the evening. Since you referenced the Historic District Commission in the section on the proposed use as a reasonable one, have you had some interactions with the HDC?
Yes, I was not present. Mr. Wilson did attend the HDC on a consultation basis and advised them that he was not going to be changing making any changes to the Front Street portion of the property. They were pleased to hear that. Again, I would note that only a portion of the property lies within the historic district. But in answer to your question, yes, they have been consulted, and because there are no changes, they won't be exercising jurisdiction over this.
Okay, thank you. Anyone else have a question for Attorney Summers? Teresa?
I do. If this was converted as a special exception, if it's a rental unit, it would need to be owner occupied. Is that the intention here with the conversion to 6, that it would be owner occupied?
Sure. Steve Wilson's going to answer that.
Well, the answer to the first part of your question is the property will be owner occupied. My daughter and her family will live in occupy the own the rear 2 units of it. And in order to accomplish that, it would need to be condominiumized. So
So the property, all 6 units will be in condominium form of ownership?
Yeah, so they'll have a common insurance maintenance program over the long haul, and there'll be a formal documentation of the, for the maintenance and ownership of the property.
Thank you.
So the units that your daughter wouldn't be inhabiting, those would be condos that would be rented out? Or would they also be owner occupied? Just
No,
wanted to.
the plan is that she would own those units, and the
As
other
well,
units
okay.
would be individually owned.
Understood.
Along, Teresa,
Baum?
I'm sorry, were you?
No,
I didn't mean to
I'm
interrupt.
done.
I guess along those lines, I wanted to confirm a couple things. I had a similar question because you've mentioned that by special exception, this could be converted to 4. Other than the owner occupancy, which has been addressed, I just wanted to confirm that the calculations have been done and the building would otherwise meet those conditions. So the open space,
That is correct.
the, I think it's minimum lot size and all of those.
That is correct.
Okay. Have you done the calculation? I know that would be for 4 units, which is what applies. Have you done a similar calculation for the 6?
Sure.
So I'll tell you that with the the conversion would require a minimum of 4,500 square feet per dwelling unit. We would be providing, even with 6 units, almost 10,000 square feet per unit. And if the property were 2 individual, it has 236 feet of frontage where 100 is required. So if we're actually 2 individual lots, it would support 2 4-unit conversions.
Is
So
the
it would qualify as
frontage,
8 units.
is the frontage you're referencing on Front Street?
Yes, it is.
Okay, thank you.
Mr. Baum?
Both of those the 2 buildings that are going to be separated, those would each meet those.
Be on the same lot.
Yeah.
Yes.
And
I think that was a hypothetical.
it was hypothetical,
Yeah,
and it doesn't apply here. I was just
Your
curious.
Right,
question about density
Yeah.
or all the other criteria for a special permit, the property does meet, except it's 1 lot.
Right. Understood. But I think what you're indicating is that it could potentially be subdivided into 2.
That is correct.
And then just I think I know the answer, but just to clarify, I think it's been stated twice that there will be no exterior changes to the Front Street facing building. The other exterior changes, is that just to get rid of that connecting structure, or are there going to be other exterior modifications to the rear, the newer building?
The walkthrough today, I was able to illustrate, we'll be taking out a area of 30 by 6, which would be 180 square feet. And we would be closing in an area of about, I would guess, less than 20 by 12 feet to close the pool off, and that connector widens that connector by 12 feet. So they'd be adding about 240 square feet. And the ordinance and so those are the only changes, and you can't see the change that I'm describing, not from Front Street, but not from anywhere off the property, literally not Seminary Way, not either of the abutting property owners. And the ordinance for conversion would allow up to 400 square feet of net addition. We're talking about 60 or so square feet of net addition.
Yeah, with permission, but I understand. It was more trying to clarify because there were statements that there were no exterior changes and then no to the front, and I just wanted to get the scope. It sounds like it's going to be minimal and mostly surrounding that connector.
Very minimal, and I think it's a very relevant question because I think one of the indications from the HDC, or one of the positives, and I think it's also a positive, is the consistency of the architecture here. So even though we're going to separate the buildings by removing that corridor, which would actually serve no purpose under our plan, we still have consistent architecture, consistent landscaping, and shared utilities, et cetera.
Any further questions for the applicant?
I just
Yes.
have a couple.
Go ahead.
There's going to be 6 units. What's the composition of those units? Are they all 2 bedrooms? Or there's 3 bedrooms thrown in there somewhere?
That's my question.
I don't know that that's been determined yet. Do you have a plan in place, Steve, or?
Well, one of the units will be a 3-bedroom unit because it is, at this point, that would be the servants' quarters, which is the former carriage house, which we saw today. 4 of them would be 2-bedroom units, and one of them would probably be a 1-bedroom unit. So that would be the mix of units. Allowing 6 units keeps the size of them down and eliminates the potential that you'd have to have 4 and 5-bedroom units of 4,000 square feet each. So that's a very relevant statistic, I think.
While you're there, just for clarification, then there will be 2 units in the modern addition in the back and 4 in the front?
Actually, yes, that's correct. When you say modern addition, that throws me off because
Right,
the
relative.
carriage house would be as it exists, as
Right.
you saw today. The 2 units out front would be symmetrical, so looking at them from Front Street, I believe at one point it was a duplex anyway, as we saw by the symmetrical entrances, symmetry of the living room, and the obvious removal of a partition wall that at one time split it down the middle. The 4th unit would occupy the indoor pool house, which the pool would be eliminated, and that's where the minor expansion would take place, and so that's new construction over
Would you
there.
just move your cursor over that so that board members who weren't there can see what you're talking about? The pool house is that extension to the left, I believe? Pool house is that indoor pool house.
Correct.
And the infill, Kevin, is just to the right of that he was talking about, that extras is
Okay.
infilling in there a little bit.
That's helpful.
And then beyond the elimination of the connector, which Shane can put right there.
Yep.
Those would be 2 units, which would be owned by my daughter and her family, and would be also connected to the 3-car garage, which would service the units out front.
Teresa?
My question was about the number of bedrooms. I think we covered that. And then at the Historic Commission, I think you mentioned the intention for that small doctor's office that just has really the bedroom and the bathroom in it. And so I just wanted to clarify here that
Well, one of the
What your
reasons
plans
that
are.
I had originally applied for 8 units was because I had read the ordinance and found that even if I wanted to use that as an ADU, it would count as a unit under your conversion. So now, having listened to the density questions and the abutters and reading those letters, that was sort of what we tried to reevaluate, and also applying the work of our architect and fire protection engineer. We're going to forego the use of that building unless somebody who lives there would come to the town and ask to use it as an office. So it wouldn't be used as a residence, but I think there's a strong potential that somebody who lived there would come back to the town and ask to use it as a home office.
So it wouldn't be conveyed as, it would be part of the condominium association as opposed to associated with one of the individual condominium units?
That's correct. I think it would make most sense to let it be assignable. In other words, the condominium in general controls it, so it's limited common area.
Okay.
And then they would be able to take the revenue from renting it to one of the residents. Let's just say they wanted to use it as an office, they would charge them, and that might help offset the costs of the maintenance of the property.
Thank you. Any further questions for the applicant?
I have one.
Martha, please.
Maybe I missed it, but Dr. Otis's office, what's going to happen to that?
Well, that's what we were just discussing.
Okay, that's what I thought.
Right,
Yep.
correct.
Ms. Summers, you did mention at one point that that it meets the density, And I wasn't sure which density you were referring to. Is it the density under conversion or?
It meets the density for 6 units. When we first applied for 8 units, 8 units would not have met the density, so we needed to ask for 2 different variances, one for density and one for the actual use. With 6 units, we now comply with the density to have 6 units, so we are now simply seeking a variance for the use to allow 6 units.
Maybe I'm not too sharp today, but I'm thinking that density for us, R1 district is one house, and that there's greater density for other districts or for conversion. And I guess I'm trying to understand which density you're applying, because this is the R2 district.
Hang on just a second. Let me.
Am I not?
I can answer those questions
Okay.
because I'm like the statistician here, okay? So if you had a conversion of 4 units, it would require each unit to have 4,500 square feet per unit. So in this case, 6 times 4,500 would be 27,000 square feet. We have 75,000 square feet. So that, or 70-something thousand square feet. So in the R2 zone, either 12,000 or 15,000 square feet would support a single-family home. So we are just under, we meet the 12,000 square foot requirement for single-family homes in the R2 district. And then in our district, it's 15,000. So we're 3,000 square feet shy or less for density for single-family houses. For density of a conversion, we have 5 times as much property as we would be required.
That answers my question. So you're talking about density under the conversion provision.
Correct.
Got it. Thank you.
Any members of the board have any further questions for the applicant before we move to public session? You all set?
Nothing for me.
Good. Thank you very much. I'm going to open it up to the public at this time with the reminder that the scope of the Zoning Board of Adjustment is rather limited. And as Ms. Summers indicated in her opening remarks, for example, parking is not an issue that comes before this board. That is something that is addressed at the planning board when the site review would take place. And so I am going to open it up to the public. And in the interest of time and of the other applicant who's going to be waiting patiently for us to reach a decision on this one, I would simply ask that anyone who wants to come up, please do so. Introduce yourself with your name and your location. And also, please let's focus on the issue that's before this board, which is strictly the use of this property in a multifamily manner. So with that, I'll open it up to the public and ask people to identify themselves.
Thank you, Mr. Chair. Members of the board, my name is Bob Casaza. I represent the abutters immediately to the right of the subject property. That's Mark and Sarah Russ at 79 Front Street.
C-A-S-S-A-S-S-A? How'd I do?
Close. Better than most. C-A-S-A-S-S-A.
Oh, I had one extra S.
One S
There we
and
go.
2 S's.
Okay.
Mindful of the chair's remarks, I'd like to make a brief introduction, hit the 5 points, make a conclusion, and then let others who are here tonight speak. And I am mindful that, as well, that you have another matter of business tonight. The applicant, as you know, has the burden of persuasion on all 5 of those variance criteria that Attorney Summers addressed in her remarks. The property is zoned for single-family use, and the property has been used as a single-family residence for decades, perhaps centuries. Improvements by a prior owner, Michael Dingman, circa 1987 to 2018, were all in support of, they were all consistent, they were all to promote that single-family use. The applicant, in his remarks to the Historic District Commission, noted upon his review of the file that the town maintains on 81 Front Street that council who appeared, representatives who appeared for Mr. Digman, they all stressed whenever they wanted to add or make some improvements, that it was all in support of the single-family use. It wasn't to put another dwelling on there. And so we're here tonight with the applicant suggesting that all of the uses that have been, all of the improvements to the property during Mr. Dingman's tenure now are antithetical to single-family use. That this property has been so improved that it no longer can function as a single-family home, and that what is fair and reasonable, in fact necessary, is that this board grant the applicant the opportunity to use it in a different way, a way that's not supported by your ordinance, a way that requires a variance, and as such requires the applicant to satisfy all 5 of those criteria. So the applicant is attempting to leverage those single-family improvements made over the years into a rationale for why you must abandon that single-family residence use and embrace an entirely different use, a use that isn't permitted without variance, and a use that has 6 units. 6 units, so going from 1 to 6. And we've heard this evening that there aren't really going to be any changes to the exterior, but there are people who are going to be in the interior and they're going to come out. And there are a lot more people who are going to do that if there are 6 units. So Mr. Forsley showed you 12 parking spaces. If you have 6 units, it's not unreasonable for there to be 2 cars per unit. And so in an area that I know you all are familiar with, that stretch of Front Street with the Exeter Inn and the Academy students and the traffic, and then we don't have Exeter High School down there anymore, but we still have that problematic traffic intersection. You are now going to be taking traffic counts from single family at 81 and turning it into potentially a 6-unit condominium with the traffic that goes with it. And so I'm not going to pretend I know your ordinance better than Ms. Summers, but I will say that I've read the introduction to your ordinance, the purpose clause of your ordinance, and I understand one of the purposes of your ordinance is to be to not have congestion on your streets and not to have undue intensity of population. And so I would suggest to the board this evening that this application runs counter to the fundamental purposes of your ordinance. And I think that's significant when you are going through those 5 ordinances, as I know you will, at the end of everyone's remarks. So the variance will not be contrary to the public interest. That's what the applicant must establish, and I would suggest to you that the applicant has not met that burden. It will increase traffic and density in an already busy area. That will impact public safety and welfare. A 6-unit condo, or I understood before this evening it was going to be apartments, but if it's going to be condominiums, is not a permitted use, and it will alter the essential single-family character of the area. Now, we've heard a presentation, and if you're like me, sort of more of a visual learner, I colored the yellow in yellow, the single-family properties, and I think just by virtue of the fact of the number of letters that you have received, the number of people who are here tonight, they absolutely believe they're in a neighborhood. They absolutely believe that there's an essential character of where they live. And I'll let them speak to you about what they think this proposal would have for an effect on that. But I would dispute that there is no essential character. I would acknowledge that there are mixed uses. There's Phillips Exeter, there's the church, St. Michael's at the end, there's the Exeter Inn. Absolutely. But those highlightings, I went in a different direction or went further than Mr. Forsley, but I think that's how neighborhoods work sometimes. They're not just 500 feet one way and 500 feet the other way.
Since we can't see that from here, would you kindly point out which is the subject property?
Certainly. So it's this one that I have my finger on right
What's
here.
the green, the park?
The green down there, yes, is the
Thank you.
park, as if you were going to the old Exeter High School.
Okay, thank you.
Okay. I can leave that right there. Changing from single-family use to a 6-condo building is contrary to the ordinance. It's not my client would submit in the public interest. The applicant must establish that the spirit of the ordinance is observed. We would contend that approval of a 6-unit condo building at a former single-family site will not observe the spirit of the ordinance. The stated purpose, the basic objective of the ordinance include lessening congestion in the streets and preventing overcrowding of land and avoiding undue concentration of population. A 6-unit condo would not further those, and we suggest that it would be contrary to those, and it would be uses that contribute to congestion and overdevelopment, which are all inconsistent with the spirit of your ordinance. Applicant must establish that substantial justice is done. I would submit there's no loss to the applicant. I was privileged to attend that site walk. It's an amazing house. It's an amazing house. If you were to end up with that as a single-family house, that's an amazing property. I don't see that there's any loss to the applicant if this request is denied. What's the outcome? An amazing single-family property of high quality, which the applicant has extolled the quality of the craftsmanship. That's what will happen. There's no loss to the applicant. And so the public's gain by denying the request is maintaining the integrity of your zoning ordinance, avoiding an increase in traffic density, and preventing an undue concentration of the population. On to the value of surrounding properties are not diminished. That's the applicant's burden to persuade you that that's the case. My clients have submitted 2 letters to you, one from a realtor, Jim Giampa, who states definitively, based on his experience, that putting a 6-unit condo next to 79 Front Street, right in this locality, will diminish the values of surrounding properties. I also asked Peter Stanhope, who's an appraiser in Portsmouth, to take a look and offer his comments. And I think if you knit those two letters together, you'll find that Mr. Giampa is very direct in his commentary, but Mr. Stanhope also supports the proposition that putting a 6-unit condo in this row of single-family properties will diminish the value. So Mr. Stanhope, in very technical terms on page 1, sets out the problem to be examined. And he says the problem to be examined is the probability of the subject's change in use from a single-family dwelling to a 6-unit multifamily, presenting a possible diminution in value to surrounding properties. And then he goes through some technical observation, but he concludes with an increase in external obsolescence, nuisance, and neighborhood nonconformity. There is evidence that a significant change in land use would have a possible negative effect, to which Mr. Giampa would say, absolutely, absolutely. And so we do not believe that the applicant can meet his burden to demonstrate. And it's the burden on the applicant to show that there won't be any diminution in value. Hardship. The applicant must establish that literal enforcement of the provisions of the ordinance will result in an unnecessary hardship on the applicant. Unnecessary meaning these special conditions of the property that distinguish it from other properties in the area. That somehow the application of your ordinance to this particular property creates a unique problem for this particular property. This property can be used in a reasonable manner. It can be used in the manner that's been used for decades, perhaps centuries, and also the applicant and his counsel have suggested to you that there may be a pathway to seek conversion. And so I would suggest to you that if your ordinance sets out that pathway, allows that pathway, that is where the applicant should go, consistent with your ordinance, and that this board should not grant a variance from the ordinance to allow for a 6-unit condominium at a site that has, for decades and perhaps centuries, housed a single-family use. And so, can relief be granted to the property without frustrating the purpose of the ordinance? I say no. Is the full application of the ordinance necessary to promote a valid public purpose? Yes, fully apply. Deny the application request. The proposed use is not a reasonable one. The applicant has a reasonable use of the property right now and may have a different use through the conversion process of the property, which is also consistent with your ordinance. And so I had the privilege of walking through that property with the applicant, as others of you did, and I was impressed by the applicant's knowledge, his vision, seeing space, suggesting how space could be used. And that was impressive, absolutely impressive, how people can, the applicant in particular, can look at space and say, this could be this and this could be that. But I also asked the board to use its vision. And if you grant this variance this evening, then I think you have to envision how other property owners could come before you and say, my house is too big. My house is too big. I want to turn it into X number of units. Or on this stretch of Front Street in the historic district, what happens to the other properties that are similar? I understand, Mr. Forsley, 1.8 acres, this is the biggest parcel, but there are, as we all know, similar structures. So we're in the moment, but like Mr. Dingman, we all have our moment and we go away. Property stays. Property stays. Variances stay with the property, as you know. And so I'll conclude my remarks and simply reiterate that as abutters, we believe the applicant has a reasonable use of the property. We understand the applicant may have a pathway to convert, and consistent with your ordinance, and consequently would ask you to deny the applicant's request to turn 81 Front Street into a 6-unit condominium. Thank you.
Thank you. Would anyone else like to speak?
My name is Sarah James, and I've lived with my family in our single-family home at 70 Court Street, 2 blocks from the property in question for the past 26 years. I submitted a letter in advance to the zoning board packet, and I just wanted to add one additional perspective. My block in Exeter is in some ways very similar to the area that surrounds 81 Front Street. Most of the buildings are single-family homes, some of which are privately owned and some of which are owned by Phillips Exeter Academy and occupied by their employees. Unlike the area we're discussing tonight, there are 3 lots in the middle of my block that have been subdivided into multiple properties, both apartments and condos. And I speak from experience when I say that the buildings which have been subdivided significantly alter the character of the neighborhood. The occupancy of the subdivided units turns over much more frequently than the single-family home. The residents do not, in general, interact with the neighborhood's permanent residents. I know the families in all the single-family homes on my block, but the residents of the subdivided home buildings, they drive in and out of their units, but they don't participate in the upkeep of their homes or the neighborhood activities. I appreciate that the subdivided buildings on my block added much-needed housing to our town, especially the units that are priced at workforce housing rates. However, I think it's important to consider the lasting effects of introducing multifamily housing to a single-family home neighborhood. The short stretch of Front Street we are discussing is a pocket of lovely homes. The families living there know each other and work together to add strength to their neighborhood and our town. And I fear that subdividing a property in the middle of this neighborhood will permanently alter its character in a way that is not beneficial and that is permanent once done.
Thank you very much. Appreciate your comments. Just to clarify, you said you're at 70 Front?
70 Court.
70. Oh,
Court.
70 Court. Thank you. Sir.
Peter Vorking, 12 Grove Street. So I live in the neighborhood. You, as a board, you have my sympathy. I'm a former chair of the Exeter School Board, and I know exactly what it's like to be a volunteer in this town.
It's fun.
Because I was sued.
It's fun.
Right? In any case,
It's a lot of fun.
when I eventually won, my comments are rather straightforward and simple. The reason there's so many people here tonight is we are, in fact, a neighborhood. In spite of what Attorney Summers said, if I ask people by a show of hands, how many of you live in our neighborhood, you would see that most of us who are here, I saw no letters in the packet in support of this proposal. All the letters that I read that were submitted in the packet that I read the other day opposed it. It is because we are, in fact, a neighborhood. We have block parties. People are included in those block parties. It goes from Court Street to Elliott Street to Pine Street to Front Street and includes Grove Street and Alewife and Hilliard Circle and so on. But we are a neighborhood. And we are a neighborhood of single-family homes. There have been other conversions. There was one attempted a few years ago across the street from us that this board denied. I hope the board would deny this one too. But most importantly, we are a neighborhood. A couple of other comments. On the hardship issue and the idea that somehow if this application is denied, that there's going to be a problem and so on. I'm very aware of the old story. It's been overly used, but I'll use it here again tonight, of a boy who kills his parents and then says to the court, I'm an orphan, you need to show me mercy. I don't think if this is denied that it creates a hardship for the individual who bought it. The individual who bought it knew there had to be multiple exceptions made in order for this to be converted. One of my problems is I followed this issue closely, and I do feel I'm working with a moving target. At first it was 8 units, then it was 6 units, then it was if we can't do it, then we'll divide it in half, and then we'll condoize it. I have a hard time following exactly what we're being asked for. The final thing I would say is it was Michael Dingman's right to buy this property. As Attorney Casassa said, it was his right to buy the property and do with it what he wanted. Admittedly, it is, the phrase was used, mega McMansion or mega house and so on. It is an over-the-top property. I toured it with many of you this afternoon. It's over the top, and who knows what its future should be. But two wrongs don't make a right. He was within his right to do what he did as a single-family house. To break it up into 4, 6, 8 units, condoize them, and so on, is something I hope this board will deny because the zoning regulations do not allow it. If the zoning regulations are wrong, change the zoning regulations. But don't make all these exceptions. It's not just one, it's a whole series of different exceptions. And to me, two wrongs do not make a right.
Thank you.
I
Just
hope
2
you
points.
deny this.
Thank you. 2 points of clarification. If you hang on a sec. 2 points of clarification. We are being asked for 6, not 4, not 2 structures, not 8, 6. Okay, so just that's clarification number 1. The second is, I'm going to leave it there. It's 6 that we're being asked for.
Okay.
There's no confusion on our part on that
Okay, it's just I
factor.
keep hearing different numbers at
Yes, there
times.
were different, but the application before us this evening is for 6 units.
Thank you.
Thank you. Next. Assuming there's a next. There's a next.
There's always a next.
There's always a next.
You make me
You
feel
people aren't here
awful.
for the fun of it, right?
I just want to say I'm not running for president, and I'm
Thank you.
not here to
Who are-
announce my
who-
candidacy.
who are you?
Paul Young, 84 Front Street. I live across the street.
Okay.
So my only question, or it's a question to the board here, or is, this is an R2 zone. There's a master plan of the city, which allows for density, higher density in other areas, less density in some. This is a less dense area. To me, this doesn't seem like this is appropriate for this board to consider anyways. It should be a planning and subdivision question for this. So I just ask the board to answer that as far as after when all the questions are done and whether that's the case. But it doesn't seem to me like a variance for something like this is appropriate. Should be a subdivision.
It's
where they can
exactly
get
appropriate for the zoning board of adjustment because there are 2 categories. You heard special exception referred to earlier, and this is for a variance. There are certain things that are guaranteed under the zoning. The zoning ordinance was approved by the voters of the town of Exeter a number of years ago, and it is amended by the voters of Exeter every year at town meeting. All we do is administer the wishes of the residents of Exeter as expressed in the zoning ordinance. There are certain things that are guaranteed by right as long as you meet certain criteria having to do with setbacks, et cetera. Those are called special exceptions. There are other items that require a variance, which is a much higher bar. But under state law, they most certainly are allowed, and they are very much the province of the zoning board of adjustment. This
Okay.
is one of them.
All right.
Yeah.
I appreciate it.
Not a problem. Thank you for asking. Part of my reason for educating on that is that when you get a crowd like this, this is how people show up and suddenly become members of the zoning board, right? So I'm going to mention that we do have 2 openings for alternate members. So if you want to sit on this side and look at you all sometime, there are opportunities to do that.
Have the sign-up sheet right here.
End of sales pitch. Would anyone else like to sit on that side of the table for a minute? That's it? Last up, I saw your hand earlier. I figured you'd stand up.
I know you pried a question out of me last month, so this time I'm going to
I did?
volunteer.
Name and location.
Barry Pastor, 100 Front Street.
Thank you.
There was a considerable discussion here about owner-owned residence. You know, that the owner has to live in the property, or an owner. If this property is made into condominiums and everybody buys their condominium, that's fine. I've seen properties, including one right next door to me, that was made into condominiums and nobody wanted to buy them. So they ended up being rental properties. And there is no owner living in the property. How do we know that the developer is not going to do that? He's not going to sit on a multi-million-dollar property with nobody interested in buying it. He would go to rent it.
Thank you for your question. Anyone else? Going once? All right, with that, no, you get but members of the public, there are a significant number of letters is that what you're referring to?
What I was going to say is that there is one person who wants to speak in support. So I don't know if the board has...
This is speak. This is not in support or negative. This is
All right.
speak.
Why don't we have one more person come up
Yep.
here, and then I'll make a few comments in rebuttal.
Right. And I do want to say that the number of letters received, while overwhelmingly negative, do include at least 2 in support. So somebody made that comment earlier, and I did want to mention that. There's a significant number of letters that have been received by this board. Ma'am.
There's several.
Hi.
All right. I'm not a great public speaker, so I'm a little anxious up here, but...
You are.
I'm Erica Wilson. I'm Steve Wilson's daughter. I am currently occupying about 1,700 square feet of the property right now.
You were gracious enough to allow us into your apartment this afternoon. Thank you.
We cleaned, so anyways, so I guess I'm a resident at 81 Front Street right now. So I just had some remarks. I typed them up and...
Yep.
All right. So my husband and I and our 2 young sons would be some of the fortunate families to call 81 Front Street our home. I've enjoyed walking from my home on Front Street through the Academy campus, where I studied as a student, to my medical practice on Front Street. It's about a 7-minute walk. I love the idea that Dr. Otis, who purchased the home in 1894, and by the way, then rented it out for about 30 years to Academy families before settling into the home himself. Like him, I'm an instructor at Tufts Medical. And I think I'd be the 3rd local physician practicing in town to occupy the home. My family, too, is settled into the area nicely. My 2-year-old son has enjoyed being pulled in his wagon alongside his 6-year-old brother on his bicycle as we head downtown to grab breakfast and some books from this awesome town library. We had fun meeting our local community members for trick-or-treat this Halloween. It goes without saying that I was pretty dismayed to read some of the local neighbors feeling that opening up this obscenely huge, beautiful, historic property to multiple individuals and families would somehow damage the quality of the neighborhood in some way. Like many neighbors who've written in, I too value the historic character of the buildings on Front Street, the walkability and the quiet of the near-town neighborhood, and the safe, active, and prosperous community that Exeter provides. Like many young families, I hope to carve out a space here to raise my family, as many of the letter writers have said they've enjoyed raising theirs. After review of the proposed variances and the collected letters from neighbors, I've grouped my thoughts and retorts into general categories. I'm not accustomed to writing this sort of letter, and after hearing a couple of the attorneys speak tonight, I'm realizing that I did misinterpret some of the general categories, but we'll go ahead. So, character of the neighborhood and concerns for increased density. Surely, foot and vehicle traffic in the area of 81 Front Street is very thick at times. I would also expect this fact to be an assumed reality to neighbors, given the long-standing history of local establishments, each within sight of 81 Front Street, including the Exeter Inn with 46 guest rooms, Epic Restaurant with space up to 150 diners for events, Phillips Exeter Academy with 1,070 students plus hundreds of staff, St. Michael Parish, which hosts 11 masses per week, and the Lincoln Street School with 400 students. Some easy napkin math, honestly, I think demonstrates that the presence of even 6 additional families would not create addition of traffic to notice this on this busy corridor. Without the outward appearance of the buildings changing or plans to diminish beautiful green spaces and gardens, I'm unsure how the presence of our families could alter what was referred to as the genteel nature of the neighborhood, unless somehow the people living within these smaller and more affordable units are themselves unfit for the character of the neighborhood. Concerns for safety and security. I'm actually really excited for this part. The scenario proposed by several letters, obviously having been influenced by a neighbor who distributed flyers to solicit letters to the board, Also mentions concerns that 81 Front Street would become a party palace, where students from Phillips Exeter Academy, some of the brightest in the world, by the way, would get drunk and high at a home rented for them by their distant families, seemingly without any legal recourse from the local police. I'm glad to report that my husband is a former law enforcement officer who specialized in drug recognition and enforcement, as well as worked in schools. Given that our 2 young boys would be living on the property, we would be especially invested in ensuring that illegal and disruptive activities are not carried out on this shared property. As someone who can remember being a teenager locally, it seems more likely to me that if a property were utilized as a single-family home by said distant parents, that this would actually pose a greater hazard for this kind of concern within the neighborhood. Additional concerns in that same vein seem to stem from the idea of occupancy leading to a danger to pedestrians using the back entrance of Lincoln Street School. As I'm sure neighbors are aware, this back drive is used by parents and educators around the opening and closing of school for drop-off by vehicles. My family would plan to occupy those back 2 units, so we'd be using that back driveway. I should hope that it goes without saying that the presence of my family with 2 young sons is not somehow expected to pose a threat to the children and families using Seminary Lane. It may not be public knowledge that the safety concerns that existed on this property when it was purchased, presumably for years. Trees were left unmanaged. They pose limb fall hazards to adjacent historic structures. One room of this giant structure was actually left unsecured and open to the elements, had no door, had fallen off its hinges. The deep in-ground swimming pool was half filled with rainwater, which is a drowning risk and proved fatal to some local wildlife, and created a literal cesspool for breeding mosquitoes. These hazards are all a top priority in rehabilitating the property, and I'm happy to report that after consultation with New Hampshire Fish and Game, hundreds, if not thousands, of amphibians were gently relocated to natural waterways from that pool before the winter season set in. Next topic was ensuring substantial justice is done in consideration of the public interest. My education is in public health, and my practice is in treating mental health within this community. And this has given me a direct and sometimes sobering view of the forces that generate suffering in our communities. Justice, of course, and again, I know it's not the kind of justice we're talking about, but justice, of course, is allowing more people to benefit from public spaces that we all deem valuable, safe, and beautiful, such as this area of Exeter we're discussing. I do not think we should strive for a situation in town where 4 kitchens and 13 bathrooms are allotted to 1 or even 2 households. I believe that inherently justice is served when we are able to turn obscenely large single-family homes into multi-family dwelling units while keeping them beautiful. Unfortunately, the attitude of not in my backyard that shuts down opportunities for beautiful, valued spaces to be shared with more families. Exclusionist attitudes were reflected in neighbors' letters, including one neighbor suggesting that the town should strive towards, quote, permitting restrained projects on historic lots, while at the same time reserving higher density developments for more appropriate locations. If I'm being honest, this argument reeks of the exhausted spin that the bulk of housing responsibility should be shouldered by poorer or more rural areas of town, more appropriate locations. Over and over again, I heard in those letters the conflation of density with degradation of character. For those non-mutually exclusive goals exists the evaluation and determination by this committee as well as the Historic District Committee. Within the guidance and guidelines of the HDC and in the hands of a reputable developer, this project would allow more individuals and families to be contributing members of this wonderful local community. The public interest, including the need for housing, should supersede the individualist interest expressed, seemingly to maintain this fantastically nostalgic, somewhat classist status quo. A condition and effort which ignores the fact that the town's population has doubled in the past 50 years. It's an uncomfortable reality that even for the young family of a local physician, adequate housing has been hard to access and afford within Exeter. Of course, one option my family has is to purchase and improve a lower cost home, further pricing out the workforce that services and supports this wonderful town. Instead of pushing properties higher and higher up the price scale, long-term visions for a sustainable community should include transitioning oversized and underutilized single-family residences into multifamily ones, with focus on maintaining the architectural heritage and beauty of the area. We should hold ourselves to ideals which can accommodate growth and public need while maintaining desirability. Lastly, the literal enforcement of the provision of the ordinance would result in unnecessary hardship. Again, misinterpretation on my part, but I would invite the board to consider the collective hardship of housing shortages. Another multi-million-dollar single-family residence, by the way, that was previously owned by an actual billionaire, or worse yet, said residence continuing to sit empty on the market does absolutely nothing to alleviate the housing struggles that are very much a concern for the greater public in Exeter, and thus contribute to the hardship of up to 6 families who are looking for housing right now, which it could easily provide residents to. I wanted to include the words of my son when we first toured the area. He's like, "What? This is so weird. Why are there 4 kitchens?" Which I thought was a pretty valid question. Just a few points of contention I had, or clarification. One was that there was this project at 69 Main Street, cited as being one of Steve Wilson's projects. It wasn't. To give concerned neighbors a more accurate depiction of Mr. Wilson's previous work, I would direct them to his company's renovation of the historic 1916 Army-Navy Association building in downtown Portsmouth. This renovation included, amongst many details, a painstaking preservation of original wood window sashes and original glass panes. And the project earned New Hampshire Home's 2018 Excellence in Historic Renovation Award. More local projects include the conversion of the nursing home at 81 High Street to 15 apartment units, as well as the restoration of the Woolrich building on Wall Street to preserve the historic facade. Rather than demolish Woolworths. I'm thinking Woolrich. No, I know. I actually used to go there. I knew it wasn't right when I wrote it. Rather than to demolish and rebuild as a previous owner and developer had proposed. I just want to say that plainly the characterization of the developer as an absentee landlord focused on profit extraction at the price of architectural beauty is not accurate. I also wanted to point out that if I'm just being really honest, a couple of the letters really struck me because they came from properties that were not currently being maintained. And those properties, those authors were very concerned about the condition of the building and the beauty of the neighborhood. When, this property we have at 87 Front Street has had 6-foot tall weeds in it for about a year. I feel like what we really need to focus on is that people need housing. This could potentially be a very beautiful project. The density works out. I think more people should be able to be a part of this really wonderful neighborhood. That's all I had to say. Thank you.
Thank you very much. I really appreciate that. Sir.
Hi, my name's Walter Payne. I live at 1 Pine Street.
Again, Walter Payne.
Okay. A-Y-N-E. Yep. So regardless of your views on the political views just expressed, I don't know that they're relevant here. And at the end of the day, as the petitioner's attorney said, the optimal size is 6 units, not 4. And by optimal, I don't believe she was referring to political objectives. She was referring to maximizing the revenue of his project. And under those criteria, then, are you allowed to buy a property and then tell the zoning board that if they don't let you maximize the value of your property, they're somehow causing a loss, which to me is entirely backwards when you bought the property knowing that those encumbrances were on it. Zoning, after all, is designed to prevent people from maximizing the value of their property. Otherwise, you would have cement factories in residential neighborhoods and things like that. So that's just what I thought. Thanks.
We actually have a residential neighborhood where there was a cement factory.
Yeah, no, I'm sure yeah, right. So, but it's just that despite the political argument she made, at the end of the day,
I would argue with you that that's the purpose of zoning, is to
Which?
allow people to maximize value. There are many other reasons for zoning other than that. But thank you. I appreciate your comments, sir. Anyone else? Hearing none?
Oh, you got someone coming.
Oh, I thought you were just heading for I thought you were heading for a seat.
The door's that way.
Yeah.
My name's Josh Siegel. I live at 36 Pine Street. We've been a resident there for 35 years, and we've seen a lot of changes in the community. We've seen some of similar stuff brought before the zoning board that has been denied. And I'd just like to speak to the fact that, and not to be duplicative, but, this is a community. There's no question about that. And is it Sarah? Is that your name? Erica. I'm sorry, Erica. Erica, no one here is against, having new people in the community.
Sir, you should address us.
Oh, I'm sorry.
Not
I'm
a fellow
sorry.
citizen.
Well, to that extent, I just want to say I think this community has been very welcoming to new people who've come into the community. I think what this is really about is changing a home that has been, single family to a multifamily for what, again, is probably profit. And to the extent that you look at the buyers who clearly knew when they bought the property that it was a sprawling, large piece of property that would need to go through some type of variance to get to this point, it's a risk-reward situation. And I'm not sure that we want to reward that type of risk-taking in this community continually, because although that's the largest piece of land right now, what's the next one? There is a next largest piece. And I know the property that, Paynes have is also a big piece of property. And what's to say, hey, this is perfect for multifamily and the variance was just given, down here, why shouldn't we give it next? And I think it's creeping incrementalism that really will change the feeling of this town. So to that extent, we're just far enough away that it's not our next door neighbors. So it's not about NIMBY for me. It's about watching this community make these changes slowly but consistently over time. And I'd like to see that stopped. So thank you.
Thank you. Anyone else? Hearing none. Ms. Summers, rebuttal.
Thank you. I would like to, before I make some comments, also note that there were a couple of letters of support in addition to the one that was read. There was a local realtor and I believe 2 other letters of support.
That's correct.
That's noted. So I think that I just have a couple of things because I think a lot of the things that I would otherwise say have been covered by Erica Wilson. I do want to note, just sort of circling back to the legal standards here, though, that there are a couple of points that the board just bear reminding. One is that there were lots of talk tonight about this is going to create a precedent. And as the board knows, that's each property needs to be viewed on its own merits. So I don't believe that that's rises to the level of concern that some of the people here discussed tonight. Second of all, I sense that there may be some, not confusion, that may not be the correct word. It may be a conflating of terms. There's lots of talk tonight, and I'm sure that much of it is sincere, but a sense of neighborhood in some of the homes in the area. We are not suggesting that doesn't exist, and I'm sure that there are neighborly feelings among many of the people that live there. However, the legal standard which this board needs to wrestle with is whether or not this proposal that is before you. And also, I might add that the notion that we have other options and so forth is not what is before this board. This board needs to consider on its merits what the proposal is that we have. I think that what we have demonstrated to this board tonight is that despite the comments tonight, that there is no monolithic character of the properties in and around Front Street right now. That is not to say, and one isn't mutually exclusive with the other, that the people who actually live out there can't have or don't have neighborly feelings for each other, but the facts as we have presented to them or presented to you tonight indicate that this is not a series of single-family dwellings, one after the other, and that what we are proposing to do is going to stick out like a sore thumb. So that is the point that I'd like to make. The other thing that I do need to address is the issue of the diminution in value. The criteria actually is that there will be no diminution in value. The evidence, as I said before, why I believe that there will be no diminution in value. However, there were a couple of points presented by the abutters, and I do feel I need to briefly respond to those. First of all, there was a letter submitted by a realtor. However, there really wasn't much to that other than to say that they thought that there might be some diminution. The appraisal prepared by, or the commentary prepared by Peter Stanhope is interesting in that he fully acknowledges that this area contains a mix of commercial uses, residential uses, et cetera, et cetera. He goes on to note that in his view that there is a possibility, and he uses those terms on several occasions. He does not say that there will be a diminution. He says that there is a possible risk. And I'm not an appraiser, so this is his technical terminology, but he attributes that possibility of a risk to the fact that there will be change. And so by that, I suppose that would mean that any time that one changes a use, that there's always going to be a diminution in value. Second, he talks about the fact that this is going to result in a nuisance. I would take issue with his conclusions. He indicates that there is going to be additional noise, traffic, gas, parking, and construction, which pose additional nuisances, and that in turn may. He also talks about the fact that assuming each unit has a minimum of 2 occupants, there's a potential for 12 vehicles. All of this, in his view, contributes to the possibility of a diminution in value. I think that he is forgetting that if this were to remain a single-family house with 16,000 square feet, I don't know who would live in that, but I would venture to guess that it would be a very wealthy person, and that very wealthy person would not be living there by themselves. They would have a family, perhaps an extended family, various servants, an au pair, a personal trainer, a chef, who knows what. All of these people are going to have vehicles. So the notion that somehow having 6 units in it is going to be on the antithesis of a single-family home with one person driving their 5-year-old Subaru like I have, it's just not going to happen. And so this notion that somehow that there's a risk of a diminution from these nuisances is just not a credible conclusion, I would suggest. So for that reason, I would, and the final thing that he points out is that this does not conform to the market. So in conclusion, his comments are about possibilities of risk, and they are attributable to things which I frankly don't think carry an awful lot of weight. So with that, I believe that the positions that we have maintained do meet our burden, and I believe that our burden is met with the other criteria, and I would ask that the board approve this variance as presented.
Thank you very much, Ms. Summers.
I have a quick question for Attorney Summers before you sit down, and that gets back to the condo approach.
Yep.
Because that was stated tonight, but it's not part of the application.
That's correct.
And it has been one of the things that has been mentioned is that generally this meets the special exception criteria. Would it be a conversion? And I know we're not looking at that tonight, but one of those factors is either owner occupancy if it's rental, or if it's condo, that doesn't apply. I was wondering if, applicant has indicated it will be a condo. I think that may alleviate some of the concerns that have been raised tonight about non-owner occupancy and transient rental, transient use of the property. And so, because I'm asking if the applicant is making that a suggested formal condition of the approval, or it's just the current thought.
I would characterize this, and I'll let Steve speak to this, but I would characterize this as a representation as to how we intend to proceed with the proposal. So I'll let Steve speak to this too, in case he wants to embellish on it.
Okay, so the question is, will I comply with the zoning requirement that if these apartments are rentals held by myself or some other entity, there will be an owner-occupied component. My daughter, this property is owned by the Wilson Family Trust, which includes me, my wife, my daughter. So she's inherently an owner of the property. If we had to rent the units because they were not saleable, or if we decided to rent the units, we would comply with your zoning and have an owner-occupied unit, which would be my daughter or someone from my family. It appears that there's an economic analysis that has to be done. I'd rather own the property over the long term. I'm just saying that would be my preference. But in today's interest rate environment and cost of product, meaning the cost of the property, I'm not sure you could garner a return on the investment that would be equivalent to meet a return on that investment of even 5 or 10 or 7%. So I'll say to you that if it's rented, we will conform with your zoning, and there will be an owner-occupied component to it. My thought is that with 6 units and 2 of them being purchased by my daughter, it has to be a condominium, because you can't own a portion of this property without it.
Understood. And that
that's
issue
my commitment to you.
Would go away. I guess.
Also, I'd like to say, if I can, 15 years ago, I bought a very similar property, which was the Eventide Nursing Home, which had been closed for 10 years. It was on 2 acres. It was across from the hospital, had multifamily properties on either side, which were grandfathered, and predominantly single-family homes. For 15 years, I've been managing that property. It's the best-looking one along the road. You can go by and see.
I live down the street from it. I'm familiar with it, and I've known several renters speak very highly.
I've had 10 people die there after living there for 10 years, or 4 people die there, and still there's 6 people that have lived there almost from day one. So there's a very consistent stream. So
no, I appreciate that, but as you know, you may not always own. I mean, this variance is going to run with the land beyond your ownership. So
that's correct, and I think it's appropriate for you to ask me that if we have to retract from selling the units to having to rent the units, that there will be an owner-occupied component. You're not allowing a variance to that right now. We haven't asked for a variance, so you have.
Well, it wouldn't actually apply. That's why I asked the question.
Well, you have my
that
commitment on the
requirement
record.
wouldn't apply, so it would be a condition of the approval if that was something the board chose to do. And I just wanted to raise that and make sure that, I just wanted to ask the question.
I appreciate the question, and you have my commitment to that.
Okay, that's very helpful. Thank you.
At this point, we will be closing the public session. Members of the public are welcome to stay, but we're going to move into deliberations. So we're simply, at this stage, going to be talking, as a wall goes up, we're going to be talking amongst ourselves. virtual wall goes up. We're talking amongst ourselves. You get to listen. Mr. Baum.
Okay, 4, the values of surrounding properties are not diminished. And again, and my notes here is that expert testimony on this question is not conclusive but can't be ignored, which I think is helpful, and that's what we spoke to before, because we do have 2 conflicting realtor letters and the Stanhope letter, which I think, as we've questioned some of the assertions that are in it. For me, and I was not able to attend the site walk, and so I'd invite other comments. But from what I've heard and what I've seen, is we've got a historic building, but that has fallen into some disrepair, and I think the pictures for me, certainly of the pool, show that. That's going to be restored, going to be brought up to code, and it will improve the value of this property. So the question is, that would typically improve surrounding property values. The question is whether the change of use from single family to 6 units, or a 6 unit rental is going to negatively affect the surrounding property values, and I'm not convinced that it is. So I would find for this in the affirmative as well, but again, I was not able to do the site walk, so I'd welcome other comments.
I'm going to look at Laura as our resident appraiser. Are you comfortable that it meets this test?
There is a professional opinion stated here, and so, I don't think I would, if I were to have this assignment, I don't think I would have landed in the same place as him. So, but I don't want to negate his opinion entirely. But I think I would, if it was my assignment, I don't think I would come to the same conclusion. So.
I think it's important to note the burden on the applicant is to show that it's more likely than not that property values won't be diminished. And so, as Laura's gone through with the appraiser's commentary, it's really giving an opinion that it's a possibility that would be a decrease in value, but not saying that that's necessarily going to happen, and also basing that off of the idea that a nuisance that interferes with the right of quiet use and enjoyment would be present for it to even be a possibility.
Well, and with no basis for that. There was nothing in that report that indicated what that nuisance would be. I don't see a cause of it, other than a preference to remain a single-family home.
Number 5.
Number 5, the enforcement of the ordinance would result in unnecessary hardship, and there are 3 factors that, 1, because of the special conditions of the property that distinguish it from others in the area, there's no fair and substantial, I'll read the whole thing, relationship between the general public purposes of the ordinance provision and the specific application of that provision to the property, and the proposed use is reasonable. So the first is we have to find that there are special conditions that distinguish it from other properties in the area. That, I think, is, that can often be a hard one. I don't think it is in this case, given the lot size and given the home, which is a factor that we are permitted to consider and should consider under case law. This house has special conditions that distinguish it from others.
Simply the maintenance,
the kitchens,
for a single-family home would require someone extremely wealthy, because the maintenance of this property would be formidable for the most buyers, even well-off buyers. So,
and then the second, and probably the most important one here, is that there's no fair and substantial relationship between the general public purposes of the ordinance and the specific application here. So, the question is, what is the purpose of the single-family requirement? And, I'm swayed by the applicant. I think that the general purpose is to avoid congestion, is to avoid over-dense lots. That really isn't a factor here. I mean, there is sufficient, no density relief is needed. This is a lot that can support this number of units without, without, I think, really being offensive to the ordinance. And then the other factor here, again, I think the fact that, this is not something that is going to be big and out of scope because they're essentially using the existing building. So this isn't some large multifamily structure that's going to go and crowd out surrounding buildings or shade buildings. So, I think considering the general purpose of single family, which is to have, not have overburdened, overpopulated lots, I think given the specific, application here and factors, I think it's met.
And the location, which is in town, mixed use.
Right.
A lot of traffic going by. It's not just a cul-de-sac in the back corner of town. And I don't think that the change in use is going to be that noticeable because the building isn't changing. And
60 square feet difference over 14,822 square feet.
so I recognize the use is changing, but as you pointed out, there could be that many people living in this home, and not all of them related necessarily, maybe employed, but not related. So is it going to be that big a difference? So I would agree with you on that.
Yeah.
Thank you, Mr. Baum.
Yeah. And the last is that the use is reasonable. And I mean, given generally, if the underlying use is permitted, it's considered reasonable, and this is residential use. It's going to remain residential use.
Right.
And so, so it's reasonable based on general, case law. It meets the criteria. It's reasonable.
Would anyone be interested in making a motion?
Well, yeah, since you've pushed me this far, I guess I will.
Felt your hand in your back, did you?
Where is my? All right, so I will make a motion to approve the application for variance for 81 Front Street from Article 4, Section 4.2, Schedule 1. And I'm reading it, but 4.3 is no longer being requested, correct? No, because that's dimensional only. So 4.2 Schedule 1 to permit multifamily use in the R2 zoning district.
No, I think you need to include both. And Section 4.3, Schedule 2. Let's clarify that before you make the motion.
Well,
or anybody seconds the motion.
Schedule 2 is density and dimensional regulations.
So this is the old?
I think this is the old. I'm going from the legal notice.
Got it. Rather than
I believe, and let me look at the application because we're not even being asked for that. I don't believe.
That's why I want to clarify it with the code, whether we need 4.3 Schedule 2.
Yeah, if you look at the red line, it's variance to Article 4.3, Schedule 2 has been crossed out.
Yes.
So you're correct, Mr. Baum, 4.2 Schedule 1 only.
And to clarify, to permit not just multifamily, but 6 residential units. And then I would also propose that on the following condition, that on the condition that that should the units become rental units, one of the dwelling units will remain owner occupied.
Is there a second?
I'll second. Yeah.
Moved and seconded. Discussion of the motion.
Is everyone clear on the motion? Because I know that was not the...
The motion is to
That
approve.
wasn't elegant, but.
It wasn't elegant. The motion is to approve the variance from Article 4, Section 4.2, Schedule 1, which is the only variance being sought at this time, subject to, with the proviso that it is, with the specification that it is for 6 units, since that is not stated clearly in the legal notice, and with the condition that should the units become rental, at least one must be owner occupied.
Correct.
So we've moved and seconded. Is there any discussion of the motion?
Site plan? Site plan.
Oh, wait, I assume site plan was a requirement because it's multifamily, but we can also...
I think it's good to throw.
Yeah, and I would, well, yeah.
Okay, so we're going to work our way back to it. You'd like to propose an amendment to the motion?
Yes.
The amendment to be?
That the, that site plan review by the planning board will be required. Or subject to, so the variance would be subject to site
plan review by the planning board.
By the planning board.
Thank you. Second to the amendment.
I'll second that.
Moved and seconded. We're going to work our way back out. Is there any discussion of the amendment? Does everybody understand the amendment? I'll call the vote on the amendment. So are we going to amend the original motion with the addition of the amendment that Mr. Baum just mentioned? All in favor of amending the motion indicate by saying aye.
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 Aye. Original motion has been amended. Is there any further comment or question about or discussion about the amended motion? Hearing none, I'll call the vote on the amended motion. All those in favor of the motion as amended, please indicate by saying aye.
Aye.
Aye. Approved, 5-0. Thank you very much. Does anyone on the board need a break? Or are we good to keep going?
I'm okay.
Pleasure, Mr. Wilson. Thank you.
What's that?
Thank you all for coming out this evening. I do appreciate it.
Who did I steal this from?
That's mine. Thank you.
Thank you. If we could have the discussion outside, I'd appreciate it. We're still in session. There's other people that are waiting. Shit, dad voice again. I keep using the dad voice.
Very long voice.
I keep using the dad voice. Using the dad voice.
Are you a dad?
Multiple times.
Yeah, see?
Multiple.
You can't help it.
Right, to continue, the application of Patrick, I'm going to say Houghton, and hope that's correctly pronounced, for a variance from Article 4, Section 4.2, Schedule 1, permitted uses to allow the proposed construction of multifamily units on the property located at 46 Main Street, and a variance from Article 4, Section 4.3, Schedule 2, density and dimensional regulations residential seeking relief from the minimum front yard setback requirement, and 3, a variance from Article 4, Section 4.3, Schedule 2, to exceed the density requirements to permit 5 units on a 26,000 square foot, I'm going to use that plus minus and say approximately 26,000 square foot lot. The subject property is located in the R2 Single Family Residential Zoning District, tax map parcel 63-1, and this is ZBA case 23-17. Is the applicant with us this evening?
Yes.
Nobody ever used the technology here.
Like 2 in one night?
2 in one night? Nobody ever uses the technology.
Should I use the microphone over there? Is that the best way to go?
Right.
I'm John Arnold from Warren Reno. I represent the applicant, Pat Houghton.
Good evening, Mr. Arnold.
Pat's with me here as well.
Okay.
I can't promise we'll take as long as the last application.
That
but
would be
we'll
just
do our
fine,
best.
thank you. Please do not.
We can live with that.
Brevity increases your odds.
Good. We'll be brief.
So does accuracy.
All right. So our project tonight's 46 Main Street. It's Cochico Auto Repair. Up on the screen, you can see what the property looks like. You're probably all familiar with it.
Sadly.
Property's zoned R2. It's about 6/10 of an acre. You can see it's right on the curve of the road, has a curved frontage, 2 existing curb cuts. And bear with me 1 second.
Thanks, Doug.
This is our concept plan. So the proposal is to demolish the existing auto repair facility and to build 5 townhome-style condominiums. You can see the configuration, 3 units in one building to the left, 2 units in the building to the right. The project requires 3 variances. The first is to allow multifamily use in the R2 zoning district. It's not an allowed use. Second is to allow a front setback of approximately 14 feet where 25 is required. The setback shown on the plan, it's measured to the front corner of the porches in front of the units. So the dark lines outlining the units or the buildings themselves, and the small lighter rectangle on the front side of the buildings are porches with a stairway leading down towards the street. And then the third variance is for a lot size or density variance to allow 5 units on a 26,000 square foot lot. I'm going to turn things over to Pat. He's going to speak just for a couple of minutes to walk you through some renderings of the project, tell you what it's going to look like, how it's going to be designed, and then I'll come back and briefly touch on the variance criteria.
Before you make the switch, would you mind if I asked you a question?
Sure.
One of the things that we try to gauge here is the scope of the request that's being, of the variance request that's being made of us. What would be allowed by right or by special exception on this property?
So by right, it's essentially single family. By special exception, it could be a duplex if we're talking residential uses. In terms of the density, it's a lot of the same discussion you had with the last application. So if this were a conversion, and it's not because there's not a residential building there today, minimum lot size per unit is 4,500 square feet. What we're providing is 5,200 square feet per unit to get to 5 units. Does that answer your question? Otherwise allowed by right in terms of the third variance would be 25 feet for the setback. We're asking for 14.
Okay. Thank you.
Okay.
Sir.
Good evening. My name's Patrick Houghton, and I was planning to take about an hour to introduce myself, but I'm not going to bore you with that tonight. Thank God. I represent Houghton Properties. We are a family real estate investment company from Manchester. I am from Manchester, and I raised my family in Manchester. However, my son spent his last 2 years here at Phillips Exeter. So I was close enough and fortunate enough to come and visit him from time to time. And I would get off at exit 9 and drive down Main Street. Certainly noticed that the service station was in disrepair, and discovered Exeter is just a real unique and special place. And I thought it would be a great improvement to the neighborhood if that building was redeveloped. So that's what brought us here. So as John said, what we're planning on building 5 condominiums on the site, a duplex style condominium, and then 3 attached condominiums. We chose a Georgian colonial architecture style because we feel it has, really fits into the architecture here in Exeter. The condominiums will be townhouse in style with one common driveway to a rear parking field, garage under in the rear of the condominium. They will be approximately 2,000 to 2,200 square feet, 3 floors of living area, 3 bedrooms with some bonus living area on the 3rd floor. And let's see, bedrooms and 2.5 baths.
Can we see the rear elevation again? You said the garage is going to be under?
Yes.
You're not asking for any parking relief, so you know the number of parking spaces required and you feel that you can meet that?
We do. So they will be 1-stall garages with, as you can see, additional parking in the parking field out back.
Based on the number of bedrooms you just outlined, there need to be 17 parking spots.
17 parking spots.
12.
1 for each bedroom, 1 for each 4 units for visitors.
I thought a 3-bedroom needed 2.
Yeah.
3 bedrooms, only 2. You're absolutely right.
2.
Thank you. You're right.
So 1, 2, 3, 4. So there's 2 spaces per unit is provided. And when you have over 4, you need a visitors?
Each 4 or subset of 4 requires a visitor, so there would need 2 visitors. So you're right, total of 12. Total of 14.
So you need some visitor spaces.
Each 4 or subset of 4 requires a visitor spot.
We can take a look at those calculations. I know we looked at them, and I think that 12 was the correct number, but I'm happy to recalculate them.
We've been known to make a mistake, too,
So-
so let's double check.
So
We make them, I make them constantly.
So you need 2 for each unit.
But I do think,
They're all 3 bedrooms.
Right.
so
So it is 12.
no, it's 10, it's 5 units, so that's 10 spaces plus 2.
10
Yeah.
plus 2 is 12.
Yeah.
He's got it.
yeah.
Okay, we're good.
It's been a long day.
Thank God, because I didn't know how to answer that question.
Yeah.
We only have 10 fingers, you know?
And we're all volunteers. Please continue, having interrupted you.
No, I'm ready for more questions. I'm complete.
1, 2, 3. So you have 5 interior spaces and 6 exterior. So there's 1 visitor space, right? Because that's 11.
1, 2, 3.
Oh, there's 7. Okay, sorry.
7, yeah.
What's the open, do you know the open space?
It's, let me pull up the plan. It's shown on the plan that you have in your packet.
It's around 13,000 square feet. Open,
So we
total
provide-
impervious is 12.5 out of 26.
We provide 52% and 40 is required.
I did want to let the board know that we did have a neighborhood meeting, and some of the envelopes were addressed incorrectly, but we did send out 40 letters to neighbors on Main Street as well as the adjacent street. And I apologize for if they didn't get to you.
You need to address us, hang on a second, we'll get to that. You need to address us, not members of the public yet, please.
So we sent out 40 notices. I'm not sure how many did not get to the correct house, but I did get a number of phone calls and had probably 6 people at the neighborhood meeting with not any opposition to the project. But I'd be happy to answer any concerns that the neighbors have tonight.
All right, so I'm going to try and summarize the variance criteria that's in detail in the application as succinctly as I can. On the public interest and the spirit of the ordinance, I'm going to lump those two together, given the overlap.
You're going to talk about all 3 variances altogether.
Correct.
We should just address them as a group. Is that how you prefer?
Yep.
Thank you.
And I'll have some specific remarks to each one, but my comments are going to be about all 3 together.
Yep.
So the test is whether the variances would alter the essential character of the locality or threaten public safety, health, or welfare. With respect to the multifamily use, I do not believe that multifamily use here is going to alter the essential character of the locality. And there's kind of 2 points here. Most notably, the use on the property right now is a non-conforming commercial auto garage. It's a non-conforming use. It's the only kind of commercial use in that pocket of the area. I think returning it to a residential use consistent with the surrounding property uses is going to be consistent with the character of the neighborhood. The second point on that is that the neighborhood already has a number of multifamily properties surrounding it. I'm just going to pop up the GIS map for 1 second. So for example, looking at the GIS map here, I'm just going to point out a few properties. 64 Main, so this is the property right here, 46 Main Street. 64 Main Street, right where the cursor is, has multifamily on it. 68, the next property over, has multifamily on it. Over on this side, 44, just the adjacent properties, multifamily, and kind of kitty cornered 41, it's multifamily as well. And then maybe
do you know, and I'm sorry to interrupt,
Yep.
but, I'm sorry,
It's in our packet.
it is in the packet. Well, and I was going to ask the number of units.
Page 3.
And
Yep.
It is, they're all laid out in the application. One that isn't laid out in the application, I'll just point out briefly here, is the 69 Main Street. I think that's probably the newest multifamily in the area. It was approved, I think, just a couple, maybe 3 years ago. That has 9 condo units in it, fairly similar to the development we're proposing.
Which, I'm sorry, what number?
69.
The old Brad's Auto Body across from the gas station.
Top left.
I'm trying to see.
Right where the cursor is here.
Oh, yes, of course, okay.
That is in a commercial zone and a permitted use. So
thank you. That was going to be a question.
just to make sure that
That changes.
we know that it's
Yeah.
not in R2.
So yeah, understood it is in a different zoning district, but it's still in proximity just in terms of the locality and the character of the locality. I think it's a relevant comparison. With respect to the lot size / density variance, so this request is a little odd, and I think to your question with the last application, what density calculation are we talking about? Because the zoning ordinance doesn't contemplate multifamily use in the R2 at all. It doesn't specify a density for multifamily use. It specifies a minimum lot size for single-family homes being 15,000 square feet, and for duplexes being 24,000 square feet. As I mentioned a moment ago, if this were a conversion, if there were a residential building there that we were converting, the minimum lot area for each unit is 4,500 square feet. And so for 5 units, you would need 22,500 square feet. Our lot is 26,000 square feet, so it's more lot area for the 5 units than would be required if it were a conversion. And as noted in the application, all of the other multifamily properties in the area have more density than what we're proposing here as part of this project. The highest density is 64 Main Street. There's 5 units there with only 1,300 square feet of lot area per unit. The 69 Main Street example we were just talking about, I think that's on the other end of the spectrum, but that only has 3,500 square feet of lot area per unit. And so with our proposal, we're providing 5,200 square feet of lot area per unit, which is greater than really any of the surrounding multifamily properties. With respect to the front setback, just going to pop up the site plan once more. Back and forth, so I have the microphone. Sorry about that. So as I mentioned at the outset, the 14 feet, what we're measuring from, I think is basically this corner right here up to the front lot line. I think that's the closest point to 14 feet. And these dark lines, like this unit, for example, the building is the dark line right here. This lighter rectangle in the front is a porch. And we're conservatively taking the measurement from the porch. Stairs and open-air porches under the zoning ordinance are allowed to be within the front yard. But it wasn't entirely clear to us what an open-air porch is and whether our porches are open-air porches. So we measured from that front corner of the porch to be conservative. That's 14 feet. The porch itself, I think, is 4 or 5 feet deep. So the actual building is more like 19 feet back from the street. The proposed setback, even at 14 feet, it's very consistent with other properties in the area. A lot of the properties in this area have a much lesser setback even than the 14 feet that we're proposing. And you can kind of see that on the GIS running along this side of the street and up here as well, and even along this side. Most of the buildings are closer than what we're proposing. The nice thing about the design, in terms of a slight reduction in the front yard setback, is that it allows the entire development to be shifted forward slightly and provide a more consistent streetscape. So you have a similar setback between our property and other properties along the street. And the other benefit to it is that it provides a little bit more space in the back of the property. So there's more room for landscaping and screening to be behind the parking lot to protect the abutters to the rear. And we kind of tried to strike a balance in splitting the difference between the front and the back to provide benefits on each side. The other thing I'd note under the public interest and spirit of the ordinance with respect to public safety, health, and welfare is that I know that this historically has been an area of some concern with respect to traffic, being near the school and having traffic backups, particularly during pickup and drop-off at the school. And we took a look at the ITE trip generation figures. I mean, this use with 5 units has virtually no trip generation. It's like 3 trips generated at the peak hours, both at morning and in the evening. And that's a decrease from what the trip generation is for the existing use that there today. So overall, it'll be an improvement in terms of traffic. The other improvement in that respect in terms of public safety, talking about traffic, is you saw, I'm sure you're familiar with it, I can put the picture back up, but just trying to be brief. The property now has 2 very wide curb cuts that come into it, and traffic is kind of disorganized. There's not a cohesive flow. That's going to be eliminated as part of this redevelopment. The curb cuts are going to be consolidated into a single curb cut. On the site plan right now, it's shown, I think it's the south side of the property, closer to the school. That's not really set in stone. This is just a layout configuration. It may well be that as part of the planning process and as the plans are finalized, that gets switched over to the northerly side further away from the school to provide a little bit more room there.
Yeah, thank you for raising that. I was going to ask that question because right now you would have the driveway for the school, the driveway for 44 Main Street, and your driveway, bang, bang, bang.
Yeah.
And I was wondering if there was a conscious decision made to put the driveway on that side.
I think it was a conscious decision to put together a quick conceptual plan for the zoning board. And I think that when more kind of planning and thought goes into the actual formal layout, it's likely that it's going to flip to the other side.
And as with the previous application, this is going to have to go to the planning board to approve for site plan approval. So there may be some feedback there as well, as well as from the members of the public. Okay, thank you.
All right, so moving on to substantial justice. This is the balancing test. Does the harm to the public outweigh the benefit to the applicant? We don't think there's any harm to the public with this application. We actually think there's a number of public benefits. One, it eliminates this non-conforming commercial repair facility.
You can use the word eyesore, it's okay.
I won't. We're under contract to buy from the owner. Yeah, I mean, I think it's going to beautify the property. I think it's going to make it more consistent with what's around there. It's going to provide housing opportunities for the town, which are in high demand, and I think it's going to generate more tax revenue as well. So I think those are all public benefits. The benefit to the applicant is obviously being able to proceed with the project. They can't do that without these variances. On the property values, this is related to really all my prior comments. We think that removing the existing service station and building this development is going to boost surrounding property values. We think the use is going to be more consistent with what's around it. Given that there's already multifamily uses in the surrounding neighborhood, there's already reduced setbacks like what we're proposing. There's already more density than what we're proposing. This project is going to be in kind with what's there, and it's not going to cause any detriment to any of the surrounding properties in terms of value. On the hardship, this is a very challenging property. I think this board is familiar with this property. There's been a number of efforts to redevelop it over the past several years. They've all been unsuccessful. I think the last one before this board may have been a proposal to put a bank on this site, which was denied. And the site's unique. I mean, you can see looking at the GIS map that it's a much larger lot, setting aside the school, which is number 40. It's a much larger lot than the surrounding lots around it at 0.6 of an acre. Most of the lots nearby are less than half that size. It's a fairly unusual shape, being on the corner of the road and also having that irregular rear lot line that cuts into the back of the property and jogs around the apartment building at number 44. And its location and its size and the commercial use that's on it tend to drive up the value of the property, and it makes it really hard to repurpose this property for a permitted use, namely a single-family residence, isn't really feasible to do. There is no substantial relationship between the general public purposes of the ordinance and their specific application to this property, given how the surrounding area has already been developed. As I said, there's already multifamily uses throughout the neighborhood. There's already more density on all of the nearby multifamily properties. There's already setbacks that are lesser than what we're proposing here. So strictly enforcing those restrictions on this property don't serve the public purpose of the ordinance. Those conditions already exist throughout, and what's being proposed is consistent with what's already there. And just briefly on the setback, I think I mentioned this before. You can look at the site plan and you may say, well, you can shift the whole development back and pick up a few feet in the front. I think technically speaking, looking at the plan, that could be done. I think that where we've positioned the development and the setback we're proposing in the front is more consistent with what's there on surrounding properties and provides a substantial benefit to the properties to the rear by providing screening and landscaping. So we think that the proposed use is reasonable. We're excited about a redevelopment potential for this property that I think would really improve the area, and happy to hear any questions that the board has.
Thank you. Any questions for the applicant?
I have a question. You mentioned a couple times proposed screening and landscaping. Mm-hmm. Could anybody elaborate on what's planned? I know you don't have a, complete site plan yet, but were you envisioning fencing, hedges, plantings? What kind of stuff were you thinking of?
Well, I think we'd be concerned about the, obviously the two properties behind us and the property to the side. So certainly either, a fence would be considered or just general landscaping.
Okay. So no specific proposal, but you're open to
absolutely
whatever requests are made at the planning board level?
Yes.
And I assume that you're not seeking a variance for height? You meet the height requirements and...
No, we think we will be okay on height.
On height.
So what are you thinking for height? Do you have any clue?
Well, I think the maximum height, 35 is, yeah, so certainly we'll be close to that.
Okay.
Yeah,
But not over.
but not over.
Or the chainsaw comes out. Suddenly you have a flat roof. Yeah.
Typically, service stations don't get repurposed to residential use because of potential contamination issues. Have you had any investigation?
Yeah, it does have a Phase 1 study that's been complete. And we did hire an engineer to look at it. And he felt comfortable that we could develop the lot into residential use. We will do a second phase
If it's indicated?
Yes.
Okay. And it's on water and sewer, so...
There is.
But the burden is on the seller, is it not? If there's contamination found?
I think that could be negotiated between buyer and seller, but, I think the DES polices that, and...
I'm sorry. Didn't interrupt.
So, and there is, funding out there to take care of any problems that they have. I actually have owned I own a former gas station. It's not residential use, but it's a restaurant on South Willow Street in Manchester, and we did the thorough study at DES, and we still continue to have monitoring wells there.
Right. Obviously, that doesn't impact the variance criteria we're being asked to weigh on tonight, but
there are no restrictions that you have any knowledge, activity and use restriction, because I'm sure there were underground storage tanks there at some point that have been removed.
Probably, yeah. Yeah.
Yes.
Yeah.
That's why we hired the experts, so he has not indicated a problem.
Are the tanks, have they been removed?
Yes.
Interesting.
Yes, years ago.
Okay.
And one other thing, I'm assuming that, and I'll just throw this out because I got to run, no basement, right? This is all on a slab. Is that correct?
No, there will be, there's a garage under out back.
Right. But the front portion will have a basement?
It will.
Oh, okay.
We expect it to,
Yeah.
Mechanicals?
Or mechanicals in the basement, yep. We expect forced hot air systems.
So that's why I asked to see the rear elevation. It looks to me like the garage is on the first floor.
It is.
It is, okay.
Yeah, so we'll...
So there will be a basement underneath it?
Not under the garage.
Not under the garage, but under the rest of
So
the first floor.
The garage will be the first 20 feet of the condominium, and then there'll be another 20 feet of basement.
Okay.
Probably not basement where you could finish and live down there, but certainly storage.
Okay.
But is it below grade?
It's below, it's below, part of it's below grade, sure.
Garage is at grade.
Yeah.
So the site, because it seems like it's a pretty level site to me.
Pretty level site, so we'll play with the number of stairs up to the porch and to the front entry, and then we are also considering a lower living area where you would step up to a kitchen, maybe 2 steps up, so that would continue to give us the height for a garage under.
Okay. And you'll excavate a little bit around the back?
I'm sorry?
Will it involve excavating a little around the back? Or
It might. It might. It might.
Just curious.
Yeah, we're going to try to steal 2 feet here and 2 feet there, and
okay.
Again, the garage ceiling is going to be relatively low.
Any further questions to the applicant before we open it up to the public? Mr. Baum? Martha?
Well, first I was wondering about snow. Where are you going to put your snow?
I believe it has been engineered where snow can be placed accordingly. I don't believe she's indicated that area, but
No, but
certainly it looks like there's,
25 feet there.
yeah.
And it is all level.
But there's a lot of room behind that parking lot.
The other question I have is that this is a corner lot, as I understand it, and that would be subject to 5.3.2 of corner lot visual clearance. But I don't have it. I would like someone to clarify this. Could you clarify it?
Yeah, I would, it is on a corner, but we wouldn't really consider that a corner lot. A corner lot would be, like.
Intersection.
A right angle.
This is an
It's-
intersection.
Well, I mean.
It sort of bends. It's not a 90-degree.
It's a curve more than
It's a curve more than a corner.
It remains Main Street
Yeah.
all along, right?
But I mean, putting a fence all the way out to the property line probably would not be a good thing, but that's something we'll look at the planning part. And if, site view of cars coming around the corner, that's something we'll have to look at on the planning end, so.
Mr. Baum, did you have a question?
I do. I have some questions about and it may just be how late we are into the night. I've got some questions about the density. So yeah, maybe more of an attorney question. One, I was hoping you could walk me through. I'm not sure I follow the density determination on the conversion. And as I look, I know that there's nothing applicable, but as I look at the square footage per dwelling unit, R2 single family 15,000, two family 12,000. The only basically if you look at the dimensional table, the only place that that would be less than what you're proposing is in the R5 multifamily. So, I mean, it just all seems like the lowest, elsewhere is 7,000. And so I'm struggling with that a little bit, and I'm not quite following the conversion calculation. And again, it may just be where I'm at in the evening. So if you can,
Yeah, no, it's confusing. So it wasn't, as I said to me, it wasn't really clear to me that we even really needed a separate variance for the density. Doug and I spoke about this for a while, and he thought it was the better practice to include it because there's not a specific limitation for multifamily density in this district. The density figures that I was talking about before are really in line with the discussion and analysis you guys had on the last application, which is looking at a residential conversion. And for a residential conversion, the ordinance says that you need 30% of the required lot size for each unit. And so if you take the 15,000 square feet that's required for single family, 30% of that is 4,500 square feet. So the math is that if you're doing a conversion, you need 4,500 square feet for each unit. 4,500 square feet times the 5 units that we're proposing here is 22,500, which is less than the 26,000 that we have. And it's really just meant, like, none of that is binding. We're not doing a conversion here. The point is really just that the ordinance contemplates a density similar to what we're proposing here in this district by special exception if we were doing a conversion. And that was kind of the closest comparison that I could come up with in terms of what the ordinance actually says, because there's no specific density limitation on the multifamily here. Sure. Did that confuse you more? Or did that make any sense?
No, I follow the logic. I'm not sure I'm fully agreement with it, but I understand where you're going and how you did the calculations. That was very helpful.
Okay. Any further questions to the applicant?
Okay.
We're going to hear from the public, and you'll have a chance to come back if you'd like. If there are any members at this time, members of the public who'd like to address the board, please step to the mic. Name, where you live, and fire away.
I'm Dave Essenser. I live at 44 Main Street. So where our kids went to school together. Right?
Yes, they did. I know it. I'm not supposed to do that, but yeah, I remember you.
That's why you didn't make him spell his name.
A lot of S's in this name, too. So.
I know who he is.
But it's good to be cautious when people are changing the rules.
Your daughters are now 30.
Yeah, that's right. And your son?
30. Daughter also, but 30.
You got a son, right?
All right, let's get that out of the way. Too good. Getting late. It's 10 o'clock.
All right, yeah, really. It's a late night for me. Anyhow, I don't see any harm to anybody here if we stuck to the ordinance. Steve, or his name is Dave and Jim, Dave and Esther, but we call him Steve. He would sell he'd be happy to sell his property. Mr. Houghton, if he was stuck to the ordinance, say he built a single family or a two-family home, he'd still make money. He'd still make a profit. And the neighbors would be very happy with sticking to the ordinance. And he just wouldn't be making as much money, that's all. And we think that 5 units and 0.6 acres, it's on a postage stamp, really. It wouldn't be, it would destroy the character of our neighborhood. And I did get Mr. Houghton's letter 3 weeks later, which was, I called him up, talked to him. But you sent the picture. I can want to bring it up to you guys.
Mm-hmm.
Yeah,
it's fine.
Back then, when what he was going to build there, it looks a lot different than the pictures we saw here. And the point I'm making is that none of the houses in our neighborhood look anything like that. Like I say, it would be destroying the character of our neighborhood.
Why do you say it would destroy the character? Just because the houses are different, or what about it would destroy?
Well, number one, the density. You got 5 units blocking, well, my view. You got lights, people coming home and stuff. People would be shining into my property, leases, Paul's, who knows what hours of night. I also told Tim of number 45 Main Street, he had sent me an email, he couldn't make it, being it's Thanksgiving their way, and he asked if I would read his email, if it's okay, or I'll give you all a copy.
45's across the street, obviously.
Yeah, Jim Upton.
Oh, got it. Yeah, okay.
Thank you.
Thank you.
Thank you, Dan.
Yeah.
Thank you.
To the board, master plans and zoning regulations are established with consideration and foresight to protect and further the character of a neighborhood. The property at 46 Main Street is in an area of historic homes, and this section of town has been under consideration in the past as a historic zone. My Greek Revival style home at 45 Main Street was built circa 1850 and was once owned by a Gilman who ran the local paper. This residential district boasts the Main Street School at 40 Main Street, only steps away from the subject property at 46. As a single-family residential zoning district, the intent to protect and further this type of family community is clear. Adherence to these zoning regulations benefits the entire community. I urge the board to protect the character of our historic neighborhood and the people who live here by denying any variance to the zoning regulations of this project. Sincerely, Tim Upton. Now, as to the value of the property, I think it would be damaging to my property and some others too. If you were to compare putting 5 units on a small lot compared to the zoning regulations, which is 2-family or a single-family home, the values would affect those properties in both directions. Do you understand what I'm saying? Comparing, obeying the ordinance compared to giving the variance. So, given that, if you have, if this board say it doesn't see it our way, I would ask for an extension so that I could have an appraisal done on the property to, give me a chance to prove that.
So you're at 44 Main Street,
Yes.
correct?
Yep.
And your property is non-conforming with 3 units. Is that correct?
I don't know if I'd use the word non-conforming. I think we're...
Well, it's a zoning word. It's not a insult. It's just a zoning word.
All right, I won't be offended.
If the zone allows for single-family use, then if you have a property that doesn't conform to that, it's not illegal. It's a legal non-conforming use, but that's what it's referred to. So, and your density is 3,049 square feet per unit, square feet of land area per unit. So you think this would destroy the character because it's got density next to your property? I'm just trying to understand.
Well, you're blocking the view, as you can see on the picture there. You didn't really answer the snow question very well. How are you going to get the snow back there? And where's it going to drain to?
It's a good question. We can.
But anyhow, I think that's what I got so far.
Thank you
Any
very
other
much.
questions? All right.
Thank you, sir.
Thanks.
Appreciate it. Anyone else?
So I am Ann Essenza, David's husband. I'm David's wife.
Really? Whatever.
Fooled us.
It's late. You can get away with that with us.
Exactly. But we do live right next door, and we will agree that what is there right now is an eyesore. There's no getting away from that. But I do take exception to calling us an apartment house. Our house is a single-family house, the original home, and the back has a little extension that has 2 of the tiniest apartments you've ever seen. So we have a 3-story single-family home. We've lived there for 35 years, raised our family, etc. When we bought our house 35 years ago, my concern was the gas station. And we were told, whether it's right or wrong, we were told that it was grandfathered in, and because of that and because of the zoning for our neighborhood being residential, that it would not be allowed to have a big business, big expansion, anything. It would need to stay basically in that so-called footprint or whatever, unless exceptions were made. Like I said, we have the main house. It's not an apartment building.
Okay.
So every house, if you look at the neighborhood, every single house around the what used to be a gas station, because we've been there a long time. It used to be a gas station. Every single house is the old, original, historic, single-family home. Just like ours, they're single-family homes that might rent out a tiny little apartment. What's being proposed, as beautiful as it is huge compared to single-family, old, original, historic-looking and feeling homes in our neighborhood. And this will change everything. That's our feeling, that's our opinion. And we propose that you do not approve, because it will change the whole character. It's just not what the residential feel of our neighborhood is.
Thank you.
Thank you. Anyone else? Don't make me beg. Come on.
Good evening, everybody. I'm Paul Mackey, 10 Ash, a butter to the property.
M-A-C...
M-A-R-K-E-Y.
Thank you.
M-A-U-S-E. It's been a gas station ever since I remember. I've grown up in my current house. Getting to it's a corner lot. Technically, it is not, but any corner lot has a stop sign on there. You put a huge house or 5 there, you're gonna turn that into a blind corner. Specifically, school traffic is going to be a nightmare. It's a nightmare now. I cannot get in and out of my street at 7:30 and or 2:30 in the afternoon. Number one, the variance will not be contrary to public interest. Like I said, it's going to turn into a blind corner. It's been a gas station. I'd be very wary of the cleanup there. The back of it used to be a junkyard. There used to be grease pits in there. The gas tanks have been removed. I don't know any remediation or any leakage. There's no monitoring wells whatsoever.
Unfortunately, sir, at the zoning board, we're specifically concerned with the issues before us.
Yeah,
and we have to assume that somebody else is going to carefully, DES is going to carefully monitor any former gas.
I sure hope so.
Yeah.
The substantial justice is done. We're talking landscaping, I hear. Going to be grass. Oh, might be a fence there. Need something concrete because I am a butter. If you go back to the line drawing that's there, you see the driveway that comes in. Anybody coming in and out of that driveway is going to be shining into my living area of the house. They do it now when they pick up their vehicles for service. They leave the lights on, they shine into my house. There's no buffer there whatsoever, so I'll stop there. The value of the surrounding properties is not diminished. Talking about setbacks, all the setbacks there have been grandfathered in. There's no new construction in that area that I can recall that has distance from the street to the...
Yeah, only 69 Main Street,
well, that's
different zone, but...
I think that's a little further back.
Yeah.
Because they have the sidewalk, a little buffer.
Back pretty far.
Yep.
Okay.
Yeah. I live there. I walk by it when I go.
We all live here too.
Yeah.
We all live here too.
Okay. Yeah. Understood.
Yeah.
64 Main Street. That's at the corner of Ash in Maine. That's a nightmare. Parking is ridiculous. Effectively turns that into a single-lane street.
I've often wondered about the parking there. So it's school. A lot of school people park there.
A lot of school people used to park on Ash Street, but when they do the rolling pickup, it has stopped. So we do get some transient people that park there during the day.
Did the what kind of pickup?
Rolling pickup?
Rolling?
I guess that's what you call it.
Okay.
It's not all released at the same time.
I gotcha.
Yeah, well,
That's a new...
Okay.
They queue up.
Yeah.
They queue up for pickup. Sometimes they block the street. You can't get out. I know they block 60 Main Street, but that house is currently on the block, on the market. Anything else?
Snow
Snow. Yeah, snow removal.
and the parking lot lights.
Yeah, snow removal. Go back to that line drawing again. Effectively, is going to put it in my backyard, the snow. And if it's graded, the grade's going to run away from the house. It's effectively going to flow in my backyard. I'm trying to build a living fence there. That's how many years old? It's
probably 10 years old now. Yeah, it's 10 years old, it's coming along good. Anything else? It's zoned for single family right now, correct? Mm-hmm. Yep, keep it that way, please. The structures are too big. Gonna go in the blind corner. People are gonna park on the sidewalk. You come around that corner, potential for an accident.
We good?
Yeah, thank you.
Thank you very much.
Thank you for your time.
Well, the only person in the room who hasn't talked yet.
Yep.
Might as well.
You're glad I didn't talk on the last one. I'm Kevin Blair. I live across the street at 55 and 59 Main Street. I own the Exeter Flower Shop, which is now closed at that location.
Yep.
My property, maybe he wanted to buy it, is getting some plans to have some changes made. I hope I can come out 14 feet and get on the sidewalk like the front of my building, which is grandfathered. And I'm not opposed to the whole situation. I think he's done a good job so far. But I think when there's a backhanded thing where when we talk condos, I was told many years ago, you get $100,000 to $80,000 a unit for the land. And, maybe we should pay a little more for the land and have less units. And I think you can say what you want about snow, but I've watched it for 25 years over there. It's going to get trucked off the property. So, you have to be aware of that as far as if there's a condo fee or whatever, they better include it. I have my own problems on the other side of the street with snow. And also, sightline is important with, I take my life in my hand every time I go to my driveway. I have blind spot. People come around the corner of Cass Street. You don't even know they're coming. They come so fast. And, that and the noise of motorcycles, et cetera, with the curve, it's a sight to be seen. So, there's some things to consider. I think he's got a good plan. Everybody wants to see it cleaned up. It's going to, it's going to be a good idea, but there are still a few quirks. I'd be willing to, even point them out to people, but more than what I've said now. But I think at this hour, I've said enough.
Thank you very much.
Thank you.
I appreciate it. I guess that's everybody. Sir?
Thank you. Just briefly. So a handful of concerns expressed, I think some common themes: lighting, traffic, snow removal, landscaping, sightlines, all that stuff. We're very sensitive to that. I think you guys understand those are typically planning board issues. They're going to be delved into in detail as part of the site plan review. And that's the time when, more detailed plans will be put together and all those issues will be reviewed. On the density, just to touch on that one more time, again, I think that the important thing is to look at what's around there. And I gave the examples in the application, touched on them in my oral remarks, but there's essentially 4 or 5 multifamily properties within just a couple hundred feet of this, and all of them have more density, more units per lot area than what we're proposing here. So even when you look at the last application, like the tough thing here that I keep on going back to is there's not really a concrete measurement for permissible density. And the analysis that was given under the prior application was that the 6 units were allowed in terms of the density of 4,500 square feet per unit. If you look at the lot size even that they had, the 1.8 acres, it wouldn't meet the density if you use the 15,000 square feet for single family. It would meet the density if you used the 12,000 square feet for duplexes. But they didn't ask for any relief because I think there's no specific requirement for density around the multifamily. I see you scowling at me a bit, Kevin, but it's, so they said.
I'm thinking.
Yeah, no, so I was just doing the numbers. So they said they had 1.8 acres, which is 78,000 square feet. And so if you did the 15,000 square feet for single families times 6 units, which is what they were proposing, you need 90,000 square feet, and they didn't meet that. You'd need 72,000 square feet if you applied the 12,000 a unit for duplexes, and they met that. But the argument that they made was that the applicable standard was the 4,500 square feet for conversions, even though it was acknowledged that they weren't doing a conversion. So my point just being that I don't think there's a specific number for density, but I'm trying to explain how our analysis flows based on the 4,500 square feet the same way the applicant in the prior hearing did. Any questions for me?
Hearing none, thank you very much.
Thank you.
We're going to close the public session this time at this point and move to deliberations. I know I said at the beginning, and I believe
R2 district. The variance is not contrary to the public interest, and the spirit of the ordinance is observed. We just talked about the public interest, that the town has a need for housing, and the explanation is that the proposed use must not conflict with the explicit or implicit purpose of the ordinance and must not alter the essential character of the neighborhood. And we talked about that the character of the neighborhood is significant amount of multifamily in the vicinity, and should not threaten the public health, safety, or welfare, otherwise injure public rights. And I would suggest that the location and the presence of other multifamily would indicate that it wouldn't threaten the safety or welfare or injure public rights. And that the benefit to the applicant, no, I'm jumping ahead. Okay, so any discussion on that?
I would just reiterate your initial comment, which I think the layout of this lot is important. I mean, both the size and sort of the shape of it really doesn't lend itself to, a single family.
And location on a curve is also not in a mixed-use area with, significant traffic. It doesn't really lend itself as well to single-family use either.
And to move this to multifamily residential is getting closer to the spirit of the ordinance than what's currently there, which is non-conforming.
Right. So it passes 1 and 2.
Okay.
Substantial justice is done.
In that case, the benefit to the applicant should not be outweighed by harm to the general public or other individuals. And although I know everybody seems to have a preference for lower density in their neighborhood, I don't see any specific harm to other individuals from it, as long as all site considerations are taken into account in the planning process, such as drainage, snow removal, screening, landscaping, all that stuff is taken care of, which is out of our purview. Then I think there should be no specific harm to other individuals.
And we need to separate here. This is just talking about multifamily as opposed to the specific density that's being requested, which is the third variance request.
Okay, good point. So the values of surrounding properties are not diminished. I think it's Asenza seems to be concerned about that. I think any new investment on this lot that is consistent with the neighborhood will enhance property values, not detract from them. And I think the use being consistent with other surrounding properties wouldn't detract from it either. So I don't have any concerns. Does anybody else want to?
Yeah, I think there'd be little you could do here to not improve surrounding property values, just given the current nature of the property.
Mm-hmm. Fair. Okay, so then we are left with criteria 5. Literal enforcement of the ordinance would result in unnecessary hardship, and unnecessary hardship means because of special conditions of the property that distinguish it from other properties in the area, A, there is no fair and substantial relationship between the general public purposes of the ordinance provision and the specific application of that provision to the property, and the proposed use is a reasonable one. So we've discussed that we think the proposed use of multifamily is reasonable in this location, and we've also discussed the individual characteristics of the parcel, its shape, its location on the curve, and so forth. And another thing that occurs to me is that if there's any additional costs because of the previous use being a gas station, that that's a hurdle for a single-family home buyer to meet. That would be less of a hurdle for a multifamily developer to meet, and I think it would be a bigger deterrent for a single-family homeowner. So, just a thought. So
your conclusion is that we're good on 5?
I think it meets both A and B. We can talk about the fact that the property is burdened by the zoning restriction in a manner that is distinct from other similarly situated properties. A, determine the purpose of zoning restriction in question, and because of the special conditions of the property, the restriction applies to property does not serve that purpose in a fair and substantial way. I think that we kind of talked about the shape and the configuration, location, all that is applicable there. And then the applicant must establish that the special conditions of the property cause the proposed use to be reasonable, and that use will not alter the essential character of the neighborhood. And I think we've already covered that as well, that it's a reasonable use and won't alter the essential character of the neighborhood. So I think we're good on item.
Any further comments or discussion on the first variance request? Would you like to make a motion on the first variance request, which is specifically only Article 4, Section 4.2, Schedule 1, permitted uses to allow the proposed construction of multifamily units on the property?
Okay. I move that we approve the request for variance from Section 4.2, Schedule 1, to permit multifamily use in the R2 district on the subject property.
Is there a second?
I'll second.
Moved and seconded. Any discussion?
Do we need as a condition for this particular variance that planning board site plan review is required?
I think that comes in.
It's a multi-family, so isn't it?
I think that was my position on the last one, but Doug recommended it. I don't see any harm.
I was just thinking back on that. He did recommend that we put it in last time, even.
I would attach it to the third variance rather than this one, though. But
Well,
because it talks about.
multifamily would require it, so I think
okay.
it makes sense. I think it makes sense here.
I think it makes sense here, too. So we have already moved and seconded, so would you like to propose an amendment to the motion?
Sure. Move
Teresa?
to amend the motion to include a condition that site plan review and approval be obtained from the planning board.
Is there a second to the addendum?
I'll second.
Moved and seconded. Any discussion of the addendum? All those in favor of amending the motion to include site plan review indicate by saying aye.
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 Aye. Motion is amended. We'll back out to the motion. Any discussion of the amended motion? Hearing none, all in favor of the motion as amended indicate by saying aye.
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 Aye. So variance request number 1 passes 5-0, which is multifamily units on the property. The second variance request is for Article 4, Section 4.3, Schedule 2, Density and Dimensional Regulations Residential, seeking relief from the minimum front yard setback requirement.
I have a question.
Ma'am.
Should we address that last in the event that it may not be needed if 5 units, if something less than?
I think they're separate because I think we need to address the setback regardless of the number of units on the multifamily property.
Got it.
Having already approved it as a potential for multifamily, without specifying the number, I still think we need to address the setback.
Okay.
Do you want to go through you want to take a turn with the 5?
Can we just discuss this before we go through variance criteria?
Sure.
So I hear from, as you stated, from every member of the public who spoke, a concern that sight distance and the blind curve is going to be an issue, and I don't feel qualified to make a judgment on that at this moment based on, having not really evaluated this proposal's safety from that point of view.
As Ms. Pennell indicated earlier, or raised the issue, this is not a formal corner lot, but it certainly is, if you look in that photograph, approaching a corner lot.
It's on a curve.
It's on a pretty tight curve. We've also heard testimony from the public that sight distances, there's a lot of traffic, the speed, the school, lots of things. And I will point out also that the corner lot requires quite a different setback. I think it was 30 feet, and going up something like 3 feet, there can be nothing, and that would be the steps and the porches and railings and all sorts of things. And so I believe that I'm comfortable making a determination on this one. Again, if we were to approve it, it is subject to site plan review. But I'm comfortable with our weighing in on this.
I mean,
and I'm also comfortable in my discomfort, to be honest with you, in allowing that because of the nature of the property. And whatever can be said about the existing use and the existing structure, it does not, other than cars that are parked in front or when there were gas pumps there getting gas there, it doesn't really impede the view. The sight line is not impeded by that structure.
The existing structure.
The existing structure.
No, it's not.
The proposed structure is going to be very, very different. We're talking 3 stories, 35 feet, right there.
So you're saying you feel negative towards that?
I do.
So I feel conflicted, not necessarily negative, because I do think that the trend in planning and neighborhood design is to have the buildings, not to have parking lots out front of everything.
Couldn't agree more.
And so I think I applaud what they're trying to do with that on the one hand, but I'm not sure because of the curve if we're comfortable with giving a relief from the front setback.
I certainly would not want to see parking out front. And as we had with the property on at the intersection of High Street and Portsmouth Avenue, where the buildings are consistently on the same setback, which is approaching 0. The new, as the existing structure, the new ones are matching up. I applaud that. I applaud that sort of effort. And that was historic district, as a matter of fact. I think that the combination of size and density here, which is our third variance request, I think there's ways of reducing the impact into the setback without forcing parking up front, for example. Whether it's 4 units or 5 smaller units. Granted, we don't get to suggest that stuff. That's planning board that goes, can you move it 3 feet? We have to say yay or nay to the application as presented to us. So we are somewhat limited there.
Well, I'm still a little conflicted, but I will be able to vote, but I don't want to make a motion.
Okay.
I have a question. You mentioned that if this was a corner lot, what the setback would be. Did you say 30?
Yeah, I believe so.
Okay.
Was it 30 feet? Does anybody remember? It's 5.
And Martha, you were like.
Martha had it. And
Martha had it. I think it was 5.4. I'll look it up while you're going through the variance criteria.
The corner lot,
The corner lot.
5.3.2.
Oh, she's good.
all right, everyone keep in mind it's past my bedtime.
Yeah, I mean, I have a little bit of trouble, just to speak while people are getting to it, calling this a corner lot.
It's not a corner lot.
Because it's, you know, I mean, it's all Main Street.
It wouldn't meet the legal definition of a corner lot.
Well, it actually would, because it says at all street intersections. And
there is a
Cass Street's coming in right there.
Yeah.
So it is open to interpretation. No obstructions to visions.
If the intersection's across the street, you want to call this a corner lot?
This is a street intersection. This is it doesn't say.
It's still Main Street, though.
Yeah, it says
The
at
intersection.
all street intersections. This is a street intersection.
Disagree with your interpretation.
That's fine. Nothing exceeding 30 inches in height above the established grade shall be erected or maintained, blah, blah, blah. Points out, so 30 feet distance from their point of intersection.
So would that be just right across from Cass Street?
Yeah.
So in theory, one of them could be close and one shouldn't be close, but that's still going to impede the vision.
That's correct.
Well, that doesn't help.
No, I know. Again, I didn't say anything specific. I simply wanted to raise the issue, and it's why I wanted to separate out the 3 variance requests.
I mean, I do think some of the difficulty here is which we often run into as a zoning board, and we're getting designs that are not final. Does make it harder, I think, to make this judgment. I personally don't have, I don't have significant concern about the setback given the surrounding area and how many existing. I realize they're non-conforming, pre-existing non-conforming, but how many homes are right on the
right on the sidewalk?
Sure. That is the nature of the neighborhood.
Consistent. I think it's consistent with the neighborhood, and more so than pushing it back to be conforming.
True.
I understand the concern and and your difficulty, Laura, because it doesn't. I feel like we don't have quite enough information to know whether it's going to cause an issue. Although it's certainly within the purview of the planning board to make sure that there's no obstructions.
Once we approve the variance request for a very specific amount, it removes it from the planning board.
Makes it pretty difficult for them to.
That was my concern, really. Not that it can't be worked out. I think it can be worked out. I think once we've approved or denied something very specific, that takes away some of their discretion.
Yeah. I think an approval would take away their discretion.
Well, denial would.
I think it's
No, because that doesn't preclude the applicant from coming back with a different application.
Well.
Is it possible to condition it in a way where it gets approved so long as the planning board is comfortable that safety has been addressed? Or is that too 1 foot in each side?
I'm going to defer to you on that one.
I don't know. I think we
Have you ever seen that?
The question is, how workable is it? I mean, I'm just trying to put myself in the shoes of the planning board, and what do they do with that? I don't know.
Did that fall under a traffic study? That's looking more like
No,
habits
that
and
generally has to do with
everything, so-
traffic trips
Yeah.
and traffic flow and such, which I don't think is an issue.
I mean, one thing to keep in mind, and we could specify, is that the request is for really the distance to the open porch, which is going to be less obstructive of vision. We could condition it on the plans proposed, which is that, the enclosed structure to be no more than I have to look at the plan to see what they've shown, but that's what's being presented to us tonight, is that it's a proposed 10-foot setback, but showing 14 feet, I think, to the open porch.
But I guess if the porch is, there's going to be stairs up to the porch, so the porch is still going to be high.
would still obstruct the
You're not going to see through the.
Well, if it's an open porch, I think that's the potential.
Yeah, but
If it's an
with the
open
stairs,
porch,
they're gonna not put anything on the bottom. They're going to enclose the bottom.
So
stairs stick out in front. The stairs go to the 10-foot.
the corner visual clearance thing says 30 inches, in height. That nothing should exceed 30 inches in height that would obstruct the view. Is there something we can do with that information? I don't know.
Another possibility is to reopen public session and ask the applicant if they would like to comment on this issue.
I'm okay with that if you want to do that.
I never have a problem with asking an applicant a direct
follow-up.
question, as long as we're not opening it up for further discussion.
Mr. Arnold, do you have a comment on the discussion regarding the variance request on the setback?
Is there any specific question, or are you just looking for general commentary?
If we were to deny the specific application, then you would be in a position of having potentially multifamily with a number of units not yet specified because we haven't gotten there, but not having the setback that's required.
If you want to give us the 5 units, we're okay with not having the setback.
Well, this isn't a deal.
Sorry, I misunderstood the comment then. So I hear what you're saying about the concern about sightline. Unfortunately, I don't have the technical expertise to weigh in on the sightline. I don't think any engineers have looked at the sightline there. Is the concern a sightline distance from where where traffic would be entering and exiting the site, or a sightline issue with just people driving around the corner generally?
People driving around Main Street, while it's not a corner lot, we understand that it is approximating one and it is a sharp curve.
And there's an intersection across the street, and there's an elementary school.
Left, and there's a lot of traffic there, especially cars parked. As one of the abutters said, one of the members of the public said, there are times that it approximates a single-lane road.
There's children.
At times it approximates a single-lane road because of the number of cars coming in and out with the school. So we're expressing a concern.
Yeah. I guess I would just say, now that I understand the concern, it specifically seems like it's the traffic driving around the corner on Main Street. I think that the issue of it being at an intersection isn't really relevant at that point. I think it's just a question of the curve of the road, because the intersection has to do with the cars coming in from the street across from this property and teeing.
That's part of it, but it mostly has to do with traffic on Main Street, and if you're within,
20 miles an hour.
hang on. If you're within the further you encroach into the setback, the more reduced the sight lines are.
Yep.
And you're proposing an encroachment into the setback of a specific amount that we're pushing back on.
And it's pedestrian traffic, heavy pedestrian traffic, as well as vehicular traffic that we're worried about. So we're just a little uncomfortable.
Can I ask this question too while you're doing it? Do you know what the distance of the property boundary? Some of the difficulty is, we're looking at the pretty limited plan. What the distance of the property line is to the edge of curb as well, because there is a sidewalk here that's going to provide additional.
Yes, if that's not counted the sidewalk, then now we're talking 20 feet. Back off the road,
right.
so then that's not as.
Is that a right way over the property boundary, or is the edge of the property boundary that inner curb to the parking lot of the
On this plan, is the sidewalk inside or outside the heavy dotted line?
The sidewalk is outside of our property, if that's what you're asking.
So you don't have the sidewalk on this plan at all?
Correct.
So your setback is from the property line, not from the, which
Which is the way it's supposed to be.
Yeah,
Which is
so
where
that's
it's supposed to be.
So we have another 6 or so feet going out and.
4.
Okay, 4, yeah.
I mean, I look at that as a layman, and you figure that car is like, 6 feet wide that's parked there, right? And that's probably 5 feet off the edge of the sidewalk. So you're talking about 11 feet to where the edge of the car is, and we'd be, 14 feet to the open porch. So it's another few feet beyond where the car is. And so just looking at this angle coming around the curve, I don't really see that as being a significant impediment to the sight line. But I'm not an engineer. I'm just looking at the picture and seeing where the car is and estimating dimensions.
We're not engineers either, which is why we value the extra commentary, so thank you for that. Is there anything else you'd like to add, either you or the applicant, before I close this?
If you look at our proposed driveway and David's driveway, if you can imagine a car pulled up to exit the property, I'm not sure that the sight line would be much different with this development. I think you could see as far as you can with the existing structure. And then, so those 2 driveways are affected. And then Ash Street is affected.
I believe that we're articulating mostly a concern for traffic moving on Main Street rather than entering or exiting either your property or any of the other schools. Any of the other.
Yeah, no, that's what I'm saying. If a car was out here, pulled to the edge of the street, I think they could see as far, even with these constructed, as the existing building. But very hard to determine the plan. But, yeah.
That's always going to be, no matter what goes there.
Yeah.
That's a tricky corner.
Yeah, it's getting late, and I think we're all getting silly. I thank you very much for entertaining the question at this stage.
Okay.
I really do appreciate it. Thank you. We're gonna step back here now.
I think knowing that drawings to the property line, not the sidewalk, now you have the sidewalk and the breakdown lane there too, which we all know the breakdown lane's part of the road when people come around that corner, but that gives you a little extra 6 feet onto that.
Yeah, before you get to assuming the property line is that second curb in, that does change things.
That makes me feel better.
And
How's
if you're
that?
14 foot back from that second curb, the higher of the 2 curbs, that's very different than I thought it was going to be. Okay.
Yeah, and from a perspective of appearance of overcrowding, I think it's helpful that this is on a curve because the way it's been presented has been...
Yeah, it'll break up the buildings.
It's a split up, so it would give the appearance of 2 separate...
Yeah, it's not a monolith. Okay. Do we want to go through quickly the 5 variance criteria for 2, because we still have to do 3 and...
Okay, so requirements 1 and 2. Number 1, the variance is not contrary to the public interest, and 2, the spirit of the ordinance is observed. We consider those together. The purpose must not conflict with the explicit or implicit purpose of the ordinance and must not alter the essential character of the neighborhood, threaten public health, safety, or welfare, or otherwise injure public rights. So the discussion we've had around that is from a perspective of the essential character of the neighborhood. I feel like the appearance we're okay with, and there's been some concern about safety with regard to the setback, but some of that is mitigated by the fact that it's not a 90-degree angle fully, and that we have this sidewalk, which is about 5 or 6 feet added space from the rendering, which seems to give us more comfort. So it seems that those...
Any further
criteria-
discussion of 1 and 2?
Okay.
Fire away.
Going on to 3?
3,
Okay.
yes, yep.
Substantial justice is done. The benefit to the applicant should not be outweighed by harm to the general public or other individuals. I think this overlaps with our previous discussion that potential harm to the public is the safety issue, and the benefit to the applicant is being able to accommodate multifamily use on the lot.
Okay.
The values of the surrounding properties are not diminished. Expert testimony.
You don't need to read
okay.
that. Don't read
We've not had a discussion about the value being impacted about with the setback and
in the specific context of the setback. Again, this
Exactly.
is all in the context of the setback.
Number 5, literal enforcement of the ordinance would result in unnecessary hardship. Unnecessary hardship means because of a special condition of the property that distinguishes it from other properties in the area. A, there is no fair and substantial relationship between the general public purpose of the ordinance provision and the specific application of that provision to the property. And B, the proposed use is a reasonable one. I'll just
So obviously it's not B, since we're not talking about the use here.
Right.
This is not a use variance. This is a setback variance.
So just quickly to go through the explanation, the applicant must establish the property is burdened by the zoning restriction in a manner that is distinct from other similarly situated properties. And just going through A, determine the purpose of the zoning restriction, and the applicant must establish that because of a special condition of the property, the restriction as applied to the property does not serve the purpose in a fair and substantial way. Special conditions of the property that we've discussed are the size of the lot and particularly the irregular shape, and that in order to accommodate the multifamily use, being able to place the property or the construction closer to the road would allow for more screening and privacy in the back.
I'm not sure that I see a hardship. I'm not sure that there's a specific hardship associated with the setbacks. I believe the setbacks are, the request is reasonable, but I'm not sure that it's based on a hardship. Are there special conditions of this property that distinguish it from other properties in the area? The setback is not being requested because of a hardship. It's not being requested because it's on a curve. It's in order to accommodate 5 units in the associated parking.
Well, I think it's also because of the character of the neighborhood and the desire to provide more buffer to the abutters to the rear and the side.
Is that a hardship?
Well, and I will say, looking at the shape of that lot and the jut out from 44 Main, it does limit, if you just look at the shape, it does poke in and limit the amount of, how far back you can move the buildings.
So is that your hardship? Is that what you're?
Well, and there is, there is case law that suggests that if the ordinance is outside of the general condition of the neighborhood, and in this case I would argue that this specific one is that, there is a hardship there. In this case, it's because if you look up and down Main Street in that area, the other buildings are right on the property line. So I think that's where you would find hardship.
Dan makes a convincing argument. Okay. Any further discussion of the variance criteria for the second request as far as changing the minimum front yard setback requirement is concerned? Would you like to make a motion, Teresa?
Sure.
Are you sure? You sounded reluctant.
Well, I think others might have their heart in it more than me.
I don't.
Okay.
I don't know whose heart is in it, so.
Okay.
There we go.
Would make a motion to approve the variance from section 4.3, schedule 2, to permit a front setback of approximately 4 feet where 25. 14 feet, I'm sorry, where 25 is required.
Is there a second?
I'll second.
Moved and seconded. Any discussion of the motion?
Do we want to amend to just confirm that it's as, it's as the plans were presented? Because I think some of the factor here for me is the fact that they presented that it'll be an open, it'll be 14 feet to the stairs, and then there'll be an open air porch. And is that, do we want to make that clear and part of a condition of this approval?
Does that limit it, because they said they might move the driveway to the other side, and so if we say as presented, does that mean they now can't move their driveway, or?
Yeah.
I don't think moving the driveway would change the setback.
No, but
If we're saying as
But
shown.
this is strictly because we've
Setback.
separated out the three variance requests.
This is just a setback.
If we add a condition or a further comment on this one, I don't think that would restrict them from making changes such as moving the driveway to the north side from the south side.
Yeah, and maybe as presented, that's sort of a cheat.
That's
I don't have
exact-
to get into the specifics, but maybe we do.
As presented is often good language to add to any motion, because it does tie more explicitly to the specific plan. The elevations, for example, are not part of the plan that's presented to us. It doesn't have to be yellow Georgian 3 stories with porches out front, right? But it does have to follow the basic footprint.
But what Kevin's saying is the porches out front are important.
The porches are, you're right. You're right.
So in that sense, we want to tie the porches in because that's why we're a little more comfortable.
So you would amend the motion to say, to add as presented in the plans submitted as part of this application?
I don't know that we want to do. I mean, I feel like we're further complicating it. I don't know that we want to, that potentially it's just the. Yeah, this is the problem with the lateness of the night. I mean, I think the goal here is, if it's important to the rest of the board, is that the distance is to the stairs and the open air porch as presented by the applicant.
Is that the language that you'd like to use in an amended motion?
What I'd like to do is specify each one, but we don't have the information to do,
Right.
So the distance to the porch. So
I believe the applicant has also submitted that not all 5 of the units have exactly the same setback, and that the 14-foot was the maximum request.
yeah.
So I think, as presented in the plan submitted as part of the application, I would make a motion that we amend, I'm not supposed to do that, I can do it, that we amend the motion to include the language as submitted in the plans as part of the application. Is there a second?
Second.
Moved and second. Any discussion of the amendment? All in favor of amending the motion, please indicate by saying aye.
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 Aye. We now have an amended motion that includes language including this plan. Any further discussion of the motion? All in favor of the motion to approve, please indicate by saying aye.
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 Aye. Okay. 2 is approved, 5-0. I know, we're all getting silly.
I'm really tired.
Yeah, we are.
My eyes hurt.
All right, I've been up since 5:32. Let's knock it off, guys. Third, a variance from Article 4, Section 4.3, Schedule 2, to exceed the density requirements to permit 5 units. This is a very specific request. 5 units on a 26,000 square foot lot.
This is the one I have trouble with.
Me too.
It just, it feels like a lot. The reason I was digging into the, density is looking, each application stands on its own, but just to think through the logic of, my thinking in the last application, one, it did seem more apples to apples to think of the, to apply the conversion requirements, because that truly was an existing building that is being converted, even if it didn't meet the 4-unit requirements.
Right.
Where these are brand-new buildings. The difference there is, given that, in that application too, though it didn't meet the 15,000 square feet per unit, it's still 13,000, and this is 5,200. And it's just significantly lower than any, basically anything else that's allowed, in any district, except for one. And so it seems too much for this lot. And again, it is somewhat different from a conversion. And to get to the point that one of the abutters made about, their non-conforming 3-unit in an existing building, where the units are all within the building, contained within the building. So I just think it's a little bit different comparison, and it does create, when you're just looking at the plan too, it's just a lot packed into this lot.
Agreed.
And it, again, we can't speak directly to snow storage and landscaping. That makes it harder, frankly, because if we had more information, it might be easier. But, there isn't a lot of room for error given the 5 units packed in. And it just, it feels like I think I had no problem with multifamily. I think it makes sense. I think the density is just more than I'm comfortable with.
Procedural question. As a former chair, would you be comfortable suggesting an alternative density, or simply saying no to the density request here?
I would just say, personally, I would just say no. I think we'd have to take the applications as they're presented.
Agreed.
We can invite the applicant to come back and propose something. And I think that's appropriate to make it clear that, because there is some case law that suggests you can't come back with substantially the same application unless you're invited. And I think it makes sense to come back with something less, but I wouldn't want to suggest it.
Very good. I think that it would be useful if you would simply quickly articulate which of the variance criteria you feel that this request does not meet.
Yeah. I know I have to articulate things now. This is the problem, this late point. As the first two are considered together, public interest and spirit of the ordinance. And, the issue is whether it doesn't alter the essential character of the neighborhood, threaten public health, safety, or welfare. I do think 5 units does negatively impact the essential character of the neighborhood in this instance. Although there are other more dense, densely developed based on, the unit per lot area. They're generally contained within a single building. It preserves more the additional yard space. It's consistent with the area, and there are a lot of, and I don't want to oversell. It is a mixed area, but there are a number of single family homes and primarily single buildings, with the real exception of 69 Main Street, which is in a different zone, and I think not applicable.
I believe all of the examples cited by the applicant are single buildings.
Yeah.
The 64 Main, 68, 44, and 41.
But you've articulated that you like the fact that it's 2 buildings, that makes it less monolithic, so.
Yeah.
Okay.
Didn't say this was easy.
Yeah. Well, but I think the difference is these are, you're generally long, narrow buildings on long, narrow lots. There are still open sight lines. And, because I wouldn't want to suggest a monolithic building, because I think that would really block, and I do have some concerns about blocking views as well from the neighbors, even with the, these are broken up, but it's still big structures without much, with a lot of mass, without a lot of, sightline breaks. So, for those reasons, I don't believe the first 2 criteria are met.
You want to follow that up with a motion, please?
Are we going to make a motion on criteria by criteria, or just?
I would say that.
Or do you want to just?
I agree that
through the
it's
rest
not
of the
me
criteria.
I apologize. Yes, you're right.
Yeah.
You're right.
I think I don't want to, but I think we should for the applicant.
Right. Substantial justice is done.
Substantial justice is done. That one I think is I have less of an issue with with that one. I mean, I think it's the weighing test, and there certainly is a detriment to the applicant here that I don't know if it's outweighed. It's probably a close call, but I wouldn't deny on that basis. Values of surrounding properties are not diminished. That one is, again, a tougher call, but without evidence.
Right.
I don't think we had enough to deny based on that basis. And then, the hardship, I do think special conditions exist, given the lot size, given the lot shape, given that it is a corner lot. The issue, I think, is whether there's a fair and substantial justice relationship between the general public purposes of the ordinance and the specific application here. This one is tough because there isn't a specific provision, but I think taking the ordinance, the general restrictions on density, which this doesn't meet, taking it in light with the closest other permitted, which would be conversion, which was for 4 units only. I think taking those in general, I think the intent here is to have, the intent of the single family is not to have overburdened, overly bulked lots, and I think that that's a factor here.
Okay.
And then whether use is reasonable, again, it's residential, so I don't have an issue there. But I think the fair and substantial relationship is where this fails.
So 1, 2, and 5A.
So,
motion?
I guess I would make a motion to deny the request for variance from section 4.3, schedule 2, to permit a density of 5 units on the property.
Articulate, please, which criteria it doesn't meet.
Oh, B, for failure to meet criteria 1, 2, and 5A.
So moved. Is there a second?
I'll second.
Moved and seconded. Any discussion of the motion? All in favor of the motion to deny, please indicate by saying aye.
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 Opposed?
I'll say nay.
I didn't hear from you.
I said aye.
You did?
Yes.
Chair votes aye. Motion to deny passes 4-1.
So, sorry, to just clarify for the record, Bob, so you vote in favor of denial?
I do.
Okay. And Laura, you did not?
Right.
Correct.
Sorry, I got confused.
Yep, sorry. I always hold my vote till the end.
Got it.
Right,
Got it.
right. And I didn't hear
We get to use
Teresa's,
aye
I didn't hear
and nay,
Teresa's
I
aye.
guess.
Yeah, right.
And I seconded,
Right.
just to be
Right.
clear.
Okay. Thank you very much. Appreciate it. Thank you for coming out this evening.
Can I make a motion to look at the minutes at our next meeting?
I think it's a damn fine.
I make a motion to review our minutes at the next meeting in December.
Awesome idea. I don't think we even need to vote on that.
Just so it, official.
Motion to adjourn?
Motion to adjourn. I move to adjourn.
All in favor?
Aye.
School sports, events, and meetings. You can watch Exeter TV online at exeternh.tv, Apple TV, and on Roku. Find us on social media for extra content. Subscribe to our YouTube channel and hit the bell to get notified about live streams and new content. Tune in to our platforms every other Friday to watch the Exeter Biweekly Report, with recaps of recent events, updates from town departments, and messages from nonprofits in your area. If you head to our website, exeternh.tv, we invite you to sign up to our newsletter to receive monthly updates about new content, upcoming meetings, and more. We'd like to thank you for taking the time to watch Exeter TV and hope that you tune in to our other content as well.